there are two opinions on the issue of industrial alcohol. I've authored the opinion for myself and 7 of my learned brothers. We have held that the judgment of the 7-judge bench in Synthetics and Chemicals Limited versus State of UP is wrong on certain aspects and have overruled the judgment to the extent as indicated in this judgment. Justice, my learned sister, Justice B.V. Nagaratna, in her separate opinion, disagrees with the opinion of the majority on specific aspects. The following were the issues which fell for our adjudication while deciding the correctness of the judgment in Synthetics. A. Whether entry 52 of list 1 of the 7th schedule to the Constitution overrides entry 8 of list 2. B. Whether the expression intoxicating liquors in entry 8 of list 2 of the 7th schedule to the Constitution includes alcohol other than potable alcohol. And C. Whether a notified order under section 18G of the Industries and Development Regulation Act is necessary for Parliament to occupy the field under entry 33 of list 3 of the 7th schedule to the Constitution. The issues are answered as follows. The expression "that is to say" in entry 8 of list 2 cannot be interpreted to circumscribe the scope of the entry. The words that follow "that is to say" are illustrative and explanatory of the scope of the provision. The expression does not limit the scope of the entry. Thus, the scope of entry 8 of list 2 cannot be limited to the production, manufacture, possession, transport, purchase, and sale of intoxicating liquor. Entry 8 in itself indicates that the intent is to ensure that it is read as broadly as possible. The entry seeks to regulate everything from the stage of the raw materials to the consumption of intoxicating liquor. Entry 8 of list 2 includes both the industry and the product of intoxicating liquor. The power of Parliament in entry 52 of list 1 is defined by the phrase control. The entry does not read as industries declared by Parliament by law to be expedient in the public interest. The entry states industries the control of which by the Union is declared by Parliament by law to be expedient in the public interest. The law enacted by Parliament must not be an abstract declaration, but must specify the extent of control that is necessary to be taken in public interest. The state legislature will have the competence to legislate with respect to the field which is not the subject matter of control. The legislative competence of the state legislature is only denuded to the extent of the control by the Union declared by the law of Parliament to be expedient in the public interest. Irrespective of whether the term industry is interpreted in a narrow or a wide manner, a point that is vehemently contested by both sides, the industry of intoxicating liquors specified in entry 8 cannot be taken over by Parliament under entry 52 of list 1 for the following reasons. And we have given reasons. The general principle is that legislative lists must be interpreted widely. The question what the court must pose is whether the two entries would overlap when interpreted widely. Then B, the only limitation in entry 52 is that the control of the industry by the Union must be necessary for public interest. Parliament can legislate on any industry, provided it satisfies the condition prescribed in the entry. Thus, entry 52, when read independent of any other entry of list 1, list 2, or list 3, does not preclude the inclusion of industry of intoxicating liquor, provided that the Union is able to prove that its control is necessary in the public interest. Similarly, entry 8 of list 2, when read independently, also includes inter alia the production, manufacture of intoxicating liquor, which is included within the meaning of industry. Thus, entry 52 of list 1 and entry 8 of list 2 overlap on the aspect of industry of intoxicating liquor. Entry 8 of list 2 is not subject to entry 52 of list 1. Thus, the state legislature has the exclusive competence to enact a law on the field in entry 8. The court must distinguish between entries that are expressly subject to entries in the Union list and entries that are not. When one entry is not subject to the other, the court must harmonize the overlap of entries. The only way to reconcile the entries is either to exclude the industry of intoxicating liquor from entry 52 of list 1 or entry 8 of list 2. The court, while reconciling the provisions, must ensure that neither of the entries is rendered redundant. E. Entry 52 of list 1 is a general entry dealing with industry. Entry 8 of list 2 is a special entry dealing with one particular industry. The consequence of interpreting entry 52 to cover the industry of intoxicating liquor is twofold. First, it would amount to deleting the word production and manufacture in entry 8. And second, the state legislature also loses its exclusive competence to legislate upon the product of the industry, rendering entry 18.8 fully redundant. As a consequence, it is clear from the analysis of the judgments in F.N. Balsara and Southern Pharmaceuticals that the meaning of the phrase intoxicating liquor in entry 8 of list 2 has been expanded beyond the narrow definition of alcoholic beverages that produce an intoxicating effect upon consumption. Liquids which may contain alcohol and which can possibly be used or misused as intoxicating liquor have been included within the meaning of the phrase. The interpretation based on legislative meaning elucidated in Gannon Dunkley, which narrows the interpretation of entries, thereby creating an exception to the rule of wide interpretation, should only be employed by courts when the twin tests highlighted above are fulfilled. The tests are A, the phrase should have acquired a well-recognized, definite and precise meaning in law, and B, the legal import of the word must be practically unanimous. Additionally, we are of the view that the legislative meaning interpretation should be adopted only when the deviation from the popular meaning of the phrase is not too wide. The legislative meaning cannot be used to artificially narrow legislative entries. The definition of liquor in pre-constitutional statutes as liquids containing alcohol cannot be transposed to interpret the legislative entry. The phrase used in the legislative entry is intoxicating liquor. The definition of one part of the expression in statutes cannot be used to interpret expressions that are used to indicate a collective meaning, particularly when the common parlance definition starkly varies. The common parlance meaning of intoxicating liquor means liquor which causes intoxication, that is, which causes someone to lose control. Thus, the three-pronged test to identify if intoxicating liquor has acquired a legislative meaning has not been satisfied. And the Constitution uses three distinct expressions relating to alcohol: intoxicating liquor, alcoholic liquor for human consumption, and intoxicating drinks. The evolution of the entries in the legislative list indicates that it was a conscious decision to substitute alcoholic liquor with intoxicating liquor in the regulatory provision. It was also a conscious decision to use different phrases in the taxing entry and the regulatory entry. We do not think that it is necessary for us to lay down the contours of different phrases used in the Constitution. That is a decision for another day and in another case. However, it is still possible to draw some inferences from the different uses. The expression alcoholic liquor for human consumption and intoxicating drink are used in the context of consumption. However, the provision relating to intoxicating liquor is not limited to its consumption. It stretches to its production, manufacture, possession, transport, purchase, and sale of intoxicating liquors and beyond. The second difference is the use of the expression intoxicating instead of alcoholic as the adjective to liquor. The following inferences can be drawn from the above differences. A. Alcoholic liquor defines the scope of the provision based on the ingredient, that is alcohol. In contrast, intoxicating liquor defines the scope of the provision based on the effect, that is intoxication. Thus, even liquor which is colloquially or traditionally is not considered as alcoholic liquor may be covered by the phrase intoxicating liquor if it produces the effect of intoxication. B. Intoxicate means the ability of someone to lose control of their behavior. It could also mean poison. Thus, the purpose of substituting the adjective which indicates the ingredient, alcohol, with the impact intoxication seems to be to enhance the scope of the entry to cover liquor which has an impact on health. And C. The public interest purpose of the provision is evident from the accompanying word from the provision, which includes every stage from its production to consumption within the scope of the entry. The public interest purpose of the provision is also evident from the evolution of the entry. The relevant entry in the 1935 Act also regulated narcotic drugs and opium along with intoxicating liquor. References to narcotic drugs and opium were deleted to prevent its overlap with entries in the concurrent list. As highlighted in the previous section, a common thread that runs through alcohol, narcotic drugs, and opium is that they are products which can be noxiously used because they are also used as raw materials in the production of other products. It is clear from the above analysis that the meaning of the phrase intoxicating liquor cannot be restricted to potable alcoholic liquor, that is, alcohol that is sold as a beverage. Alcohol is an inherently noxious substance that is prone to misuse, affecting public health at large. The purpose of entry 8 is to cover alcohol that could be used noxiously to the detriment of public health. The entry covers all alcohol that could be prone to noxious use. It also covers variants of alcohol that are not used for the preparation of potable alcohol, but which could be misused to harm public health. This interpretation is in consonance with the mischief sought to be covered by the entry. Thus, while the entry covers ENA and rectified spirit, which are used in the preparation of potable alcohol, it also covers variants of alcohol, such as denatured alcohol, which though are not used in the preparation of potable alcohol, are prone to be misused. Item 26 of the first schedule to the IDRA must be read as excluding the industry of intoxicating liquor as interpreted in this judgment. The holding in Tikaramji is not relevant to the dispute for the following reasons. We have interpreted the phrase intoxicating liquor in entry 8 to include ENA, since it could be noxiously used. And, notwithstanding the above, if the ground for overruling the holding in Tikaramji is that manufacture or production cannot be disconnected from raw materials, it would also equally apply to the industry of intoxicating liquor covered by entry 8 of list 2. We have concluded that the words that is to say in entry 8 are illustrative. They are not exhaustive of the contents of the entry. Exclude raw materials used for the production of intoxicating liquor merely because the entry does not expressly provide for them. On an application of the principle that entries ought to be interpreted widely, the raw materials for the production and manufacture of intoxicating liquor, as interpreted in this judgment, would be covered by entry 8. The issue of whether Section 18G of the IDRA covers the field of entry under entry 33 of list 3 does not arise for adjudication in view of the finding that denatured alcohol is covered by entry 8 of list 2. The reference is answered in the above terms. The registry is directed to obtain administrative instructions for placing the matters before the appropriate bench. Synthetics as indicated in the judgment.
Respected states can levy a fees of state has to. Very good.
I have perused the comprehensive and erudite opinion authored by Honorable the Chief Justice of India, Dr. Dhananjay Y. Chandrachur, on the questions referred to this 9-judge bench. I respectfully dissent on certain aspects of the said opinion and express my reasons therefore. The sum and substance of all the questions referred to this bench could be crystallized on the short point for consideration, namely whether the expression intoxicating liquors in entry 8 list 2 of the 7th schedule of the Constitution of India includes within its scope and ambit industrial alcohol, and consequently whether a state legislature has the competence to legislate on industrial alcohol. My short answer is that there is a lack of legislative competence in the state legislature when viewed from the constitutional framework and statutory framework of Industries Development and Regulation Act 1951, for short IDRA, passed by the Parliament on the strength of entry 52 list 1 of the 7th schedule, and having regard to section 2 of the said act, read with its various provisions and the first schedule thereto, particularly item 26, which deals with fermentation industries other than potable alcohol. However, the discussion on scope and ambit of entry 33A list 3 of the 7th schedule of the Constitution is distinct and shall be discussed later. Therefore, Synthetics and Chemicals Limited has been correctly decided by the 7th-judge bench of this court on the aspect of section 18G of the IDRA occupying the field, and consequently whether the state legislatures are denuded of their powers on the content of the subject matter of the said section in the context of entry 33A list 3 as per the first part of article 254(1) shall be adverted to later. I propose to discuss reasons for the aforesaid view I have a lengthy judgment and therefore a lengthy index with 24 points, and they may be perused. Analysis. The survey of the aforesaid decisions of this court and their analysis clearly indicate the golden thread of continuity in all of them. That is, this court has been clear on what is meant by the expression industrial alcohol, as simplified to refer to all alcohol which is not fit for human consumption as a beverage or non-potable alcohol. By contrast, the use of the expression potable alcohol refers to intoxicating liquors used for human consumption as a beverage or as a drink. However, in paragraph 85 of Synthetics and Chemicals, the expression both potable and is an inadvertent insertion, inasmuch as there was no reason to state that licenses to manufacture potable alcohol was vested in the central government. Therefore, to that extent, the judgment in Synthetics and Chemicals calls for clarification. The judgment of this court in Synthetics and Chemicals was also clear about the controversy before it, namely the competence of the Uttar Pradesh state legislature to impose vent fee on industrial alcohol when the same is a product of fermentation industry and therefore under the control of the union. However, the sum and substance of the controversy has to be answered by this court on the premise that despite there being clarity in the minds of the authorities under the states as well as the center, repeated imposition of imposts in the form of tax or excise duties have brought several cases before this court for adjudication. Ultimately, those who are in the business of industrial alcohol or intoxicating liquors, namely non-potable and potable liquor respectively, are clear about the nature of their business and the products that they are dealing with. Hence, I feel that it is incumbent for this court to enhance the clarity and not create a further legal regime which would cause confusion and legal uncertainty in the economy. At the outset, I may refer to Cooley's constitutional limitations. Quote, in interpreting clauses, we must presume that words have been employed in their natural and ordinary meaning. Says Chief Justice Marshall, quote, the framers of the Constitution and the people who adopted it must be understood to have employed words in their natural sense and to have understood what they meant, unquote. This is but saying that no forced or unnatural construction is to be put upon their language. And it seems so obvious a truism that one expects to see it universally accepted without question. But the attempt is so often made by interested subtlety and ingenious refinement to induce the courts to force from these instruments a meaning which their framers never intended. That has frequently become necessary to declare this fundamental maxim. Therefore, one task before this court is to ascertain to what extent intoxicating liquors has acquired a natural and ordinary meaning at the time of the Constitution coming into force. In my view, what is required to be seen is the nature of the product which leads to such an intoxicating effect upon human consumption of the same. Here, the expression consumption must be explained. It is not all kinds of human consumption, direct or indirect, which is the determining factor. It is only direct consumption, that is, as an ingestion by the act of drinking as a beverage or a drink. An indirect consumption by use of alcoholic liquors as a raw material for any other product, industrial, medicinal, or a toilet item, cannot be included as part of Entry 8 List 2. Secondly, merely because there can be a potential misuse of industrial alcohol, for example, by converting rectified spirit as a beverage, which has an intoxicating effect, Entry 8 List 2 cannot be stretched to include such industrial alcohol. The prevention of abuse of industrial alcohol as a beverage is also covered under Entry 8 List 2. Thus, what is carved out of fermentation industries in Entry 24 List 2 is only intoxicating liquors used as a beverage and thus for direct human consumption. The said subject is placed in Entry 8 List 2. This would imply that the rest of fermentation industries would be within the scope and ambit of Entry 24 List 2, which is subject to Entry 52 List 1 and is a scheduled industry as per Section 2 read with Item 26 of the first schedule of the IDRA. One must also be cognizant of the fact that Entry 8 List 2 concerns itself with intoxicating liquors even from a historical perspective. One must note that a construction of Entry Act List 2 should not potentially give the states the legislative competence to legislate on industrial alcohol, which is a scheduled industry under IDRA. That Entry Act List 2, which deals with intoxicating liquors, cannot also subsume industries for manufacture of industrial alcohol, etc. Viewed from another perspective, the exception, that is the mischievous use, cannot lead to governing of the norm, original intended use, through such construction of Entry Act List 2. Put into practice, this would translate into legislative regulation of production, manufacture, possession, transport, purchase, and sale of the entire industry and product of industrial alcohol only because of its possible misuse or mischievous use. This reading would be tantamount to attaching to the constitutional intent and absurdity, that is the part governing the whole, or in other words, bringing within the ambit of Entry Act List 2 something which is an exception as a main aspect of the entry. A power to legislate as to the principal matters specifically mentioned in the entry also includes within its expanse legislation touching incidental and ancillary matters. However, ancillary matters by a backdoor cannot be included within the entry beyond what is covered as the principal. Herein, the ancillary matter being prevention of mischievous use of industrial alcohol would be within Entry Act List 2, but industrial alcohol as such would not be included. Merely because industrial alcohol by a process can be converted to alcohol for human consumption as a beverage, that does not mean that the state legislature can regulate industrial alcohol. On the other hand, the states as per Entry Act have the power to regulate intoxicating liquors, which is for human consumption as a beverage, and is in that regard have the power to prohibit industrial alcohol being converted to alcohol for human consumption as a beverage. This is in order to protect the health of citizens, which is a direct principle of state policy and Article 47 of the Constitution, and in order to prohibit unauthorized use or misuse of industrial alcohol produced in the state from being converted and sold as intoxicating liquors meant for human consumption as a beverage. Then I have looked at the matter from another perspective. One of the contentions raised in this batch of cases is with regard to whether the central government has to, in fact, issue a notified order with regard to regulating the supply and distribution and trade and commerce of any article or class of articles relatable to any scheduled industry, so as to indicate that the state legislature cannot pass any legislation under Entry 33A List 3. In my considered view, the fact that an industry is a scheduled industry under the IDRA would imply that at the time the central government is empowered to, at any time, the central government is empowered to issue a notified order providing for regulating the supply and distribution and trade and commerce of the products of such a scheduled industry. But in the absence of there being an issuance of a notified order as such, can the state legislature be denuded of their powers to pass any law under Entry 33A List 3? Having regard to the emerging situation in the economy in the matter of supply and distribution and trade and commerce of the articles or class of articles related to any scheduled industry, the central government may issue a notified order for the purpose of regulating the same so as to secure its equitable distribution and availability at fair prices of the product of such industry. Situation may suddenly arise, make or expedient to issue a notified order under Section 80G of the IDRA. One cannot envisage the emerging circumstances in an economy such as the Indian economy, where the need for issuance of such a notified order would arise. It could be, for instance, to curb hoarding and black marketeering of a particular article of a scheduled industry in order to stifle price rise. It could be for ensuring a minimum or maximum price for any article related to a scheduled industry, which is a raw material or ancillary input for a product or article of another scheduled or non-scheduled industry. Sudden rise in prices of commodities or articles relatable to any scheduled industry due to natural disasters, floods, famines, financial emergency, or such other reasons could necessitate issuance of a notified order under Section 80G of the IDRA. Of recent occurrence is the COVID-19 pandemic, which would have necessitated issuance of notified orders on certain articles relating to scheduled industry. The field of legislation must therefore be left open for the central government to act by issuance of a notified order as and when thought necessary or expedient to secure an object as stated in the said provision. But can it be held that in the absence of any such notified order issued by the central government, the states could pass laws under entry 33A list 3? Would it lead to a legal confusion and an overlapping and contradiction? This is because if it is held that in the absence of there being a notified order actually issued by the central government under section 18G of the IDRA, the states are empowered to pass laws under section entry 33A list 3, and such laws are in fact made under the aforesaid entries by the states, and the central government subsequently decides to issue a notified order under section 18G of the IDRA. The question would be, what would be the fate of the laws made by the state if they overlap with the notified order issued under section 18G of the IDRA? Obviously, the control of any industry being taken over by the union under the provisions of the IDRA would imply that the central government is empowered to issue a notified order in terms of section 18G of the Act, and that when it is necessary or expedient to secure the equitable distribution and availability at a fair price of any article related to any scheduled industry. In such a case, the notified order being issued under 18G of the IDRA would have an overriding effect on the state's laws, if any made under entry 33A list 3 in regard to trade and commerce, etc. A law made by the state under any entry of list 3 or concurrent list is no doubt subject to Article 254 of the Constitution. However, entry 33A list 3 is a very unique entry in as much as the said entry would have to be read in the context of entry 52 list 1, which relates to IDRA, which is enacted by Parliament, and under the said entry, inter alia section 18G of the IDRA exists. When entry 52 list 1 and any law such as IDRA empowers the union or central government to take certain steps under the provisions of the said act, it would imply that the state legislature is per se denuded of its powers to make any law under entry 33A list 3. Applying the above interpretation, when once the central government has the powers under section 18G of the IDRA in the matter of regulating supply, etc., then the field has been occupied by the central government to issue notified orders as and when necessary. I have brought this interpretation under the first part of Article 254(1), which says, if any provision of a law made by the legislature of a state is repugnant to any provision of a law made by Parliament, which Parliament is competent to enact. In this case, the IDRA is a law which has been made by the Parliament. Therefore, I have said from 110/1953, the field has been occupied. Now, this is what in paragraph 85, synthetics and chemicals also says, where it says the state cannot claim that under entry 33 of list 3, it can regulate industrial alcohol as a product of the scheduled industry because the union under section 18G of the IDR has evinced a clear intention to occupy the whole field. The aforesaid observation, which has led to a reference to this 9th bench, has to be considered in light of entry 52 list 1, entry 33A list 3 and section 18G of the Act. Then I have given the principle of the doctrine of occupied field with regard to Article 254, first part, subclause 1, and the application of the doctrine of occupied field is a technique adopted by the constitutional courts in order to ensure that there is no potential conflict that could arise between the state laws and the existing parliamentary law, having regard to the nature of the legislative powers, their importance in the socio-economic sphere of governance in the country, and such other considerations. I have also referred to the judgment Ma Aparam Puri of the 5 judges bench, and I have said that the states are denuded of their powers under entry 33A list 3 insofar as scheduled industry is concerned. Then I have said, without going into the other aspects of the case, in my view, this court was not right in holding that since no order was issued by the central government under section 18G of the IDRA, the legislative field was open to both the central as well as the state governments to take action. That portion of the judgment in Tikaramji, in my view, is not correct. Chand, State of West Bengal versus Union. Then I have said something about Importance of industrial alcohol in the Indian economy. It is necessary to note the importance of industrial alcohol in the Indian economy. Industrial alcohol is important to Indian economy for it is used in at least two sectors. One, as a key feedstock for production of various chemicals in the chemicals industry, and two, as liquid fuel to be blended with petrol. As regards the chemical industry, the 22nd Five-Year Plan 2012 to 2017 of the Planning Commission notes that alcohol-based chemical industry occupies an important place in the Indian chemical industry and is a key contributor to the growth of the sector. It also notes the several alcohol-based chemical industries such as in synthetic yarn, drugs, pharmaceuticals, agrochemical, personal care products, dyestuffs, pigments, etc. Then with regard to the contribution of ethanol blended with petrol EBP program of the Government of India, I have referred to the unstart question of 20th December 2023, where the Minister of State for Ministry of Consumer Affairs, Food and Public Distribution has said as to how the Government of India has been implementing EBP programs and has fixed the target of 20% blending of ethanol with petrol, and how the capacity must increase from up by in 2025 to 1700 crore liters for the meeting the target. Then I have given the Ministry of Petroleum and Natural Gas, Government of India, their ethanol-based growth story. Then I have also referred to Sarkaria Commission report when it comes to these important principles, where I quote again, if the principles of union supremacy are excluded from Articles 246 and 254, it is not difficult to imagine its deleterious results. There will be every possibility of our two-tier political system being stultified by interscene strife, legal chaos, and confusion caused by a host of conflicting laws, much to the bewilderment of the common citizen. The federal principle of unity in diversity will be very much a casualty. The argument that the states should have legislative paramountcy over the union is basically unsound. It involves a negation of the elementary truth that the whole is greater than the part. My opinion basically goes in favor of parliamentary supremacy, subject to whatever has been clearly reserved for the states under list 2. Then I have given my conclusions on interplay of legislative entries. Then I have given effect of overruling synthetics and chemicals. To the effect of overruling India Cement, I had 8 reasons, but here I have 9 reasons as to what would happen. And ninthly, I would say the Amendment Act 2016 has brought much needed clarity on the issue and is the correct position of law compatible with the scheme of legislative competence as under our Constitution. I have already held that merely because industrial alcohol can be easily manufactured into or misused to becoming industrial alcohol would not grant states the competence to wholly regulate industrial alcohol. State legislatures only have legislative competence over what is intoxicating liquor as a beverage. Therefore, the judgment in synthetics and chemicals is good law and was most correct in postulating that state legislatures will only have the competence to prevent misuse in interest of public health. For the aforesaid reasons, I am of the view that although the judgment in synthetics and chemicals calls for only a clarification, which I have referred to above, it does not require any overruling. I have given my answers to the questions formulated in paragraph 32, my answers to the conclusions of learned Chief Justice in paragraph 33. Reference is answered in the above terms. The registry to place the matters before Honorable the Chief Justice of India for seeking orders for being listed before the appropriate bench. I must place on record my sincere appreciation to the learned Attorney General, learned Solicitor General, and their teams, learned Senior Counsel appearing for the respective parties, learned Instructing Counsel, and learned Counsel for the respective parties for their valuable assistance in this bench, to this bench. Thank you.
Immensely grateful.
Grateful to the court. Grateful.
I just signed it.
Last word on the matter to my learned brother, Justice Rishikesh Roy, with your permission on both sides.
After listening so intently to the judgment authored by Sister Nagaratna, I nearly pulled out my pen to sign. It was so persuasive. This is perhaps the second time in a 9-judge bench combination we are sitting, and she's given a dissenting judgment. I counted 8 reasons while I was reading the judgment a few days earlier, but she clarified that 9 judges. But in any case, the judgment is now delivered, and since the case relates to intoxicating liquor, so I would suggest to the winning side that happy hour begins now.
But for the losing
But-
side
but
also,
Yes.
they need alcohol, the same thing.
The embrace, but don't lose control. Either way.
Grateful to the court.
So alcohol is a panacea for everybody, that means.
Yes.
The winning and the losing. Thank
We'll
you.
just be back. The following issues arise for our consideration. A, whether the appellant, who is not a party to the settlement between the second respondent and the corporate debtor, has locus in the proceedings before this court. B, whether the National Company Law Appellate Tribunal erred in invoking its inherent powers under Rule 11 of the NCLAT Rules 2016 in the presence of a prescribed procedure for the withdrawal of CIRP, that is the corporate insolvency resolution process and settlement of claims between parties. And C, without prejudice to the above, whether the NCLAT adequately addressed the objections raised by the appellant while exercising its discretionary power under Rule 11 of the NCLAT Rules 2016. Before answering these questions, we have traced the evolution of the legal provisions which concern the withdrawal of CIRP after the admission of the application moved by a creditor. We observe, not only is there an exhaustive framework to deal with withdrawal and settlement, but the evolution of the law and the creation of a comprehensive framework indicates an attempt to reduce reliance on discretionary powers. As detailed earlier, the IBC and the allied rules and regulations in their original form did not provide any procedure for the settlement or withdrawal of claims after the admission of the application by the creditor. This court was compelled to invoke Article 142 in decisions such as Lokhandwala-Kataria Construction and Uttara Foods and Seeds. To reduce reliance on Article 142, Section 12A and Regulation 30A were introduced to provide a detailed procedure for such cases. In fact, the ILC report, which led to the inclusion of Section 12A, specifically discussed and rejected the proposition that Rule 11 can instead be used for this purpose. Next, this court in Swiss ribbons held that since there was no prescribed framework to allow settlement or withdrawal of claims after admission of the application, but before the Committee of Creditors was constituted, Rule 11 of the NCLT rules may be invoked. In response to this, to reduce reliance on the inherent powers under Rule 11 and provide certainty, necessary amendments were made to Regulation 30A. There is now a detailed procedure to deal with withdrawal or settlement at both stages, post-admission, before and after the COC is constituted. In view of this detailed framework, the requirement to invoke the discretionary powers such as Rule 11 of the NCLT rules or Rule 11 of the NCLAT rules, or even the power of this court under Article 142 no longer arises. A. Firstly, that the application is to be submitted by the IRP rather than the parties themselves is not a distinction without difference. As noted earlier, once the application is admitted and CIRP is initiated, it is the IRP who takes charge of the affairs of the corporate debtor. The proceedings become collective proceedings, and the interests of the former management of the corporate debtor become disjunct from the interests of the corporate debtor. Therefore, the parties, such as the former management of the corporate debtor, must submit their application for withdrawal through the IRP, who is now the person in control of the insolvency proceedings. To subvert this requirement would run contrary to the scheme of the Insolvency and Bankruptcy Code and the underlying principles discussed in this judgment. And B. Secondly, the NCLT cannot be considered a post office that merely puts a stamp on the withdrawal application submitted by the parties to the IRP. The Insolvency Law Committee report, in response to which the parent provision, Section 12A, was introduced in the IBC, specifically discussed the possibility of the creditors, apart from the applicant creditor, agreeing to a settlement as the underlying reason to permit withdrawal even after the initiation of the CIRP. It was never fathomed by the ILC that withdrawal of claims would remain a unilateral process, even though the application is admitted and CIRP has been initiated. Similarly, this court in Swiss ribbons, in response to which Regulation 30A was amended, specifically observed that in cases where withdrawal is sought after the initiation of CIRP, but before the COC is constituted, the NCLT must decide on the application after hearing all the parties concerned and considering all relevant factors on the facts of each case. Therefore, the NCLT does conduct an adjudicatory exercise when the application for withdrawal is placed before it and the procedure is not a mere technicality. On the locus standi of the appellant, we have observed the provision for appeal stipulates that any person who is aggrieved by the order of the NCLAT may file an appeal before the Supreme Court within the prescribed limitation period. Similar language is used in Section 61 of the IBC, which provides for appeals to NCLAT from orders of the NCLT. The use of the phrase any person aggrieved indicates that there is no rigid locus requirement to institute an appeal challenging an order of the NCLT before the NCLAT, or even an order of the NCLAT before this court. Therefore, we have said that the appellant is not an unrelated party to the CIRP but is in fact an entity whose claims have been verified by the IRP by a letter dated 19 August 2024. The appellant, who claims to be a financial creditor, has expressed reasonable apprehensions about the prejudice it would face if there were round-tripping of the funds and the prioritization of the debts of the second respondent and operational creditor. In an event, the appellant had moved an application before NCLT seeking impleadment as a respondent, and the objections of the appellant were specifically recorded and addressed in the impugned judgment. Therefore, there is no doubt that the appellant falls within the ambit of the phrase "any person aggrieved" and has a locus standi to institute the present civil appeal before this court. Next, on the approach of the NCLT in the impugned judgment, we observe when settlement was sought by the first respondent before the NCLT, the Section 9 petition had been admitted, and the Section 7 petition had also been disposed of on that basis. However, admittedly on this date, that is 31st July 2024, the COC had not been constituted, and the NCLT subsequently stayed the formation of the COC. In such cases, the legal framework mandates that one application for withdrawal be moved, 2, the application has to be moved through the IRP, and 3, it be placed before the NCLT for approval. None of these requirements were met in the present case. First and foremost, there was no formal application instituted to seek the withdrawal of the CIRP. The settlement agreement was taken on record and approved by the NCLT based on the submissions and assurances of the counsel before it and the affidavits / undertakings filed by the parties. Further, the first respondent, who is a former director of the corporate debtor, did not move the application through the IRP and instead approached the NCLT directly. Finally, the request to approve the settlement was moved before the NCLT during appellate proceedings instead of being placed before the NCLT. Despite these grave deviations, the NCLT still proceeded with approving the settlement and setting aside the CIRP by invoking its inherent power under Rule 11 of the NCLT rules. We are of the view that recourse to Rule 11 of the NCLT rules was not warranted in the present circumstances. As noted above, inherent powers cannot be used to subvert legal provisions which exhaustively provide for a procedure. To permit the NCLT to circumvent this detailed procedure by invoking its inherent powers under Rule 11 would run contrary to the carefully crafted procedure for withdrawal. In the impugned judgment, the NCLT does not provide any reasons for deviating from this procedure or the urgency to approve the settlement without following the procedure. The correct course of action by the NCLT would have been to stay the constitution of the COC and direct the parties to follow the course of action in Section 12A, read with Regulation 30A of the CRP Regulations 2016. Accordingly, we hold that, for the above reasons, we allow the present appeal and set aside the impugned judgment of the NCLAT dated 2 August 2024 in the above terms. At this stage, it would not be appropriate for this court to adjudicate on the objections of the appellant to the settlement agreement or merits. The issues raised are the subject matter of several litigations in different fora, including the Delaware Court, and investigation by various authorities, including the Enforcement Directorate. During the course of the proceedings before this court, the Committee of Creditors has been constituted. The parties are at liberty to invoke their remedies, to inter alia seek a withdrawal or settlement of claims in compliance with the legal framework governing the withdrawal of CIRP. Nothing in this judgment would be construed as a finding on the conduct of any of the parties or other stakeholders involved in the insolvency proceedings. The amount of Rs 158 crores, along with accrued interest, if any, which has been maintained in a separate escrow account pursuant to the order of this court dated 14 August 2024, is directed to be deposited with the Committee of Creditors. The Committee of Creditors is directed to maintain this amount in an escrow account until further developments and to abide by the further directions of the National Company Law Tribunal.
Only one thing, my lord, if your lordships can modify the last part,
Yes.
it may remain, my lord, till the NCLT decides, because the committee is one person, the appellant. He is the committee, my lord. There is not committee in the sense we understand.
We have considered it now, we can't modify this.
Deeply obliged.
My lord, your lordships can consider, my lord. Anyway, I leave it. So I leave it.
You have said that the money should be brought into the Committee of Creditors. The Committee of Creditors will maintain it
Subject to the, my lord, the final decision of NCLT, at least, my
Now
lord.
that the judgment is rendered.
Lord, Lord, can it be? I leave it. Now I leave it at that. Make a request that can be made subject to the decision of the NCLT when we follow the procedure, my lord. But I think, can that be done, my lord?
No, we'll comment in what we have dictated.
If you did.
Lords, may I mention, my lords, there's an urgent bail. We have moved the mentioning slip, my lords. Your lordships have been listing bail matters, allowing mentioning for bail. Today also, a lot of
When was the impugned order passed?
my lords, the impugned order is dated 30th of September 2024. It's bail. I'm in custody for 6 months, my lords.
So it will be circulated. It will be circulated.
That's
Just
what
send an email. It will be
I
circulated.
have done that, my lord.
Yes.
And there's one other prayer, my lord. There's a before your lordships, my lords, today in chambers, my lord. There's a prayer for, there's an application for
That will be dealt with.
lordship, please.
Lordships, I have
There is-
the similar prayer with regard to bail and quashing, your Lordships. And
When is the impugned order passed?
your Lordships, 21st September.
It will be listed.
No, your
you don't
Lordship.
have to mention. These matters are listed as a matter of right and cause. You don't have to mention at all.
Anxiety is that it must be before we break for vacation, because in the meanwhile,
Also, you say that in the
Lordships, there's something very concerning which I can pass on to your Lordships. To the court master, your
I
Lordships.
just general directions also.
On Friday, if
Yes,
I may.
Well,
Lot
can
of
I
bails
make one?
got listed, my lord, subject because of your lord.
Yes.
Can I make one request? My lord? One matter is showing regarding, my lord, the coastal way in Bombay on 4th.
Yes.
We have moved one on behalf of the corporation. We are moving an application. It is fine. My lord, there are two prayers. Matter be not deleted, and IA also be listed.
We'll list the IA basically and matter not to be deleted. No difficulty. Just send an email so that it
Yeah, my lord,
Of course, my lord, we'll give it to the learned.
Lordship, may I mention a matter, tarik number 48993 of
You
2020.
sent an email.
Yes. My lord, I have followed the procedure, my lord.
So why are you mentioning it? It will be listed there.
I
Is
did
it,
not-
is it fresh?
Yes, my lord.
When did
This
you-
matter pertains to the discrepancy in the main exam of Rajasthan Judicial.
When have you circulated the email?
Yesterday, my lord. 10 to 10.
Tomorrow?
Grateful, ma'am.
May I mention, my lord,
Your Lordships.
I've got an exemption from this honorable court to surrendering, and that exemption is required to make some compliances before 5th of November. That compliance is having some technical difficulties. That compliance is having some technical difficulties, therefore a modification application is pending to be listed before.
That you have to mention before Justice Rishikesh joined. Will not take the, but don't say that I've given you liberty to mention that.
No.
That judge's pension matter is hanging was.
Oh, yes.
It's covered, so it hardly takes 2
It's kept tomorrow.
to
He says it's on board tomorrow.
It's on board today also.
All right.
It just,
Your Lord.
if your lordship indicates the time, I can ask the attorney general.
Before marital rape starts, we'll take up the judge's pension matter. It just take 5 minutes. Who's appearing for the other side?
The attorney general was appearing, so I'll inform him.
The attorney has not come back to India. He was traveling overseas. So, anybody here for the Union of India? That's when the attorney is coming back on work. Yes. Kanu, when is he coming?
I think he's coming back in a week. So maybe the end of the week he'll be coming. I'm
But
not sure if he's
we'll
not-
have to deal with it because somebody is the pension of our retired judges, High Court judges is held up. Before to be able to hear it. Just see who's appearing.
get in touch with the AG's office.
Yes, just see who's appearing. We'll take it up. Because we'll keep it tomorrow so that in case the AG can't appear tomorrow, somebody else can appear. But we'll dispose it out before Diwali because it's a matter pending. That's the High Court judge's pension, right? Some of the High Court judges.
And it's entirely covered by lordship judgment. I gave the judgment to lordship.
It's an individual case. How many?
Individual case. It's a one judge.
One judge.
From Allahabad.
Didn't we do this? We'll take it up right now. We'll take it up right now and pass some interim order because I should have done a judge with you.
We disposed of then.
Your Lordship, I'm mentioning two fresh matters.
In this case, is this the broader issue about the NPS?
No, not the broader issue. It's an issue which the lordships have decided in case of judges of the High Court who are elevated from the higher judicial service, my lords. Then, my lord, part 3, my lord, will apply to them. And that's one part. And the second, that if they have their functioning as an advocate, will have to be reckoned with.
That was that judgment in the Punjab.
Judgment is squarely, so both aspects are squarely covered.
Why didn't you do this since the AG is not here? You give a copy of that judgment to Mr. Agarwal. Mr. Agarwal, make sure somebody appears tomorrow even if the AG is not here. So that's, there's some appearance.
Yes.
I think we'll take it.
Lordship may have it tomorrow, my lords?
Yes, we'll take it up tomorrow.
Great.
Your Lordships, I'm mentioning two fresh matters. They were tentatively listed for the 25th. However, the status has changed yesterday. The petitioners are facing eviction.
Have you sent an email?
I am requesting.
Your voice is cracking, Miss Ayushi. You have been muted.
Mail.
Have you sent an email?
I've sent an email, Your
When was the
Lordships.
impugned order passed? When was the impugned order passed?
Yes, Your Lordships. I've sent an email.
No, when was the impugned order passed? What is
It
the
is July 24, Your Lordship.
What is the urgency?
July 2024.
Order is passed on 24th of July and now you're coming here on the 22nd.
1st July 2024, Your Lordship. I'm just requesting that the matter not be deleted. Your Lordship, the petitioners are facing eviction. I'm just requesting that the matter not be deleted.
Who's mentioning at some education matter?
Yes, my lordship, I am mentioning the MBBS students matter.
1 second. What are you mentioning?
My lord, I'm mentioning for my matter is pending since 2019 is education matter and admission for MBBS in Chandigarh Medical College. And the interim order was passed in 2019 that further OBC seats should be considered for the next. But my lord,
sir, who's your lawyer?
Party person. I'm party person.
Okay, fair enough. Have you please? Are you in a position to send an email to the court?
Yeah, I sent. My lord, I sent this email on 18th of October.
All right, 18th of October, the email has been sent. I'll give a listing.
My lord, otherwise 31st October is the last of the admission.
Which is the bench? Which is the bench?
At your bench, my lord.
All right.
And one thing more, the similar matter is pending. The court number 3, 1765 of 2019 SLP, and it is tentative date is 25th of this October.
All right, I'll just take a call and I'll assign it if it's the same as court number 3.
25th tentative date is given.
Let me just check, verify it, and I'll pass orders, administrative orders. Yes, item.
Lordship, may I mentioning item, my lordship, fresh matter. It is regarding the MBBS students admission, my lordship.
When was the order passed?
4th October 2024, my lordship.
Have you circulated an email?
Yeah, I have sent an email, my lordship.
If you have circulated an email, it will be automatically listed before the vacation.
My lordship, the third round is also, my lordship, finished in the admission quota, my lordship. The similar matter, interim order has been passed in SLP number 21536.
Right, we'll give you an early listing.
Obliged.
I'll give it before the vacation. Yes.
May it please. So this is my contempt petition, Millers. There are 5 instances of contempt which I am alleging. Millers, I will.
Who's appearing for the respondent?
For the respondent.
Why have you not? You are to deliver the possession of the flat within 2 months. You are directed to pay 7% interest on the unpaid price of rupees 8 lakhs and maintenance charges.
Unpaid price on 8 lakh milots. Apart from that note, para 13, sub para 6 milots. The original flat was for 1200 square feet milot. It was enhanced to 1800 milots. That was also considered by this honorable court. It's there in page sub para milot.
Well, let's just see that.
May I, in that case, may I start because it is my case that they are not interpreting the order in the right manner.
All right, let's see the order of our court.
Please,
Where do we get the order of the court?
Well, Annexure P1, it starts at page 19, Milords. The operative portion is para 13, but I would like to draw your attention to 4 observations even prior to that. If your Lordship may kindly have page 20, para 5.
All right. Just read that.
Yes, Milord. No, the amount has been crystallized on 4 different places by your Lordships in this order. The first is at para 5. Please have the 5th line from the top. A balance of rupees 8 lakhs remain to be paid to the first respondent towards the purchase consideration. Now, please have the page over at page 21, para 8.
Has that? Allow me read the.
Yes.
Page 21, para 8. At this stage, the narrow issue which merits consideration is that pursuant to the order passed by the NCDRC, the first respondent has demanded interest at the rate of 24% per annum, both on the maintenance charges and on the outstanding consideration of rupees 8 lakhs. The review was sought on that ground before the NCDRC. Now, your Lordships will kindly have para 10. Para 10, your Lordships have recorded that, on the other hand, counsel appearing on behalf of the first respondent submits that the first respondent had to maintain the flat for all these years. Moreover, it has been submitted that the consideration of rupees 8 lakhs remain to be paid, and hence the payment of interest at the rate of 24% per annum at the agreed rate is valid. Now, your Lordship will have paras 11, 12, and 13 from page 22 onwards. Your Lordship has that, please?
Yes.
Having regard to the narrow conspectus of the case, we have the considered view that the appellant must pay the unpaid consideration of rupees 8 lakhs and the outstanding maintenance charges, both 1 and 2, must be paid together with reasonable interest. The appellant is obtaining possession of the flat, and hence the demand of the developer for payment of both the above components together with interest is fair. However, in the facts and circumstances of the case, we scale down the interest from 24% annum to 7% per annum. Now, your Lordship, para 13, we accordingly issued the following directions. The first respondent shall, in terms of the impugned order of the NCDRC dated so and so, recompute the outstanding amount which is due and payable by the appellant by computing interest at the rate of 7% per annum. The interest at the rate of 7% per annum, as noted in 1 above, shall be payable both on the component of the unpaid consideration of rupees 8 lakhs and the outstanding maintenance charges. The first respondent shall, within a period of 2 months from the date of this order, render the flat in a fit and habitable condition for occupation and hand over possession of the flat to the appellant, complete in all respects and with all the amenities. In terms of the agreement with the flat buyer, the deficiencies which have been noted in the flat in paragraph 3 of notice dated 14 July 2022 shall in particular be rectified by the first respondent before handing over possession. First respondent shall enter into a registered deed of conveyance with the appellant simultaneously with the handing over the balance consideration, which shall be computed in terms of the present order. The appellant shall be informed of the fresh computation of the amount which is due and payable in terms of the present order within a period of 2 weeks from the date of this order. The price which is payable for the residential flat at the contractually agreed rate shall be fixed on the basis of super area of 1835 square feet.
So one thing, therefore, our order makes it very clear.
Please.
So in clause 1, we said unpaid consideration of 8 lakh.
Yeah.
The super area of the flat had increased from 1200 to 1835.
Please.
So in the last clause, that is clause 6, we say the price which is payable for the residential flat at the contractually agreed rate shall be fixed on the basis of the super area of 1835. Right? Now, 1 second.
Yes.
Now, what is the rate which is agreed to in the agreement?
Please have page 30.
Just tell us, why
Yes.
keep on reading pages. Tell us it's a
1250 square feet, 2560 per square feet.
2560.
Yes.
Right? Now, therefore, multiply 1835 by 2560. Just answer our questions. Don't argue with us.
Yes.
It's a contempt petition. We don't have to exercise contempt jurisdiction.
Please.
What does it come to? 1835 by 2560?
That will come to the calculation that they submitted, that will come to 22 lakhs 97,600.
22 lakhs 97,000.
600.
All right. We'll take it as 22 lakhs 98,000.
Your Lordship will take it 23 lakhs for the purpose of discussion, because I'll develop on that.
All right. So now 23 lakhs is the unpaid, is the price for the total flat of 1835 according to them.
Yes.
Now tell us, how much have you paid out of the 23?
My unpaid consideration is quantified at 8 lakhs.
No, that's your submission.
Yes.
Tell us, what installments have you so far paid for the price?
Everything but for 8 lakhs.
So have you paid 20? Have you paid so far 15 lakhs?
No. I have paid 48. The backstory is this: there was an original buyer by the name of Madhu Jindal. Her agreed price with them was 32 lakhs. She had paid 24 to them, 8 was outstanding. Now, when I bought from her, my agreement with her was for 56. So out of which I paid her 48 and 8 was to be payable to the builder.
So the original agreement with of your vendor with the builder was for 32 lakhs.
Please. Out of which original
24 lakhs was paid.
She had paid. 8 was outstanding.
And that was for the entire super area of 1835.
It's for 1200.
No, plus.
So one second. 1 second. Did the area of the flat increase after the earlier vendor sell the flat to him?
But in the in order, that's very clear.
No, but tell us.
Yes, it did.
Your 1 second.
Please.
This area, just 1 second. The flat which is sold to him is an identical flat which was sold to that, what is her name?
Madhu Jindal.
Madhu Jindal. Identical flat.
I sold her a 1200 square feet flat of 2 BHK.
But it's the same flat, right?
No, it was
a flat of 1200 square feet can't suddenly after the transaction become a flat of 1800 square feet.
Right.
It's the same flat. No. The identity of the flat is same. Have you constructed additionally some area?
It was increased, my lord, and that has been considered by this.
So what was the date? What was the date of the agreement with the earlier buyer, Madhu Jindal?
Madhu Jindal and the builder was 14th August 2011.
All right. And what is the date of the agreement between him and Madhu Jindal?
Me and Madhu Jindal?
Yes.
No, that is
14th August 2011.
No, I'm so sorry, Milad. 14th
their agreement.
Sorry, 14th August 2011 is my agreement with Madhu Jindal. Madhu Jindal agreements with them was of 31st October 2010. About a year before mine. 11 months.
31st October 2010.
Please.
Now the flat was under construction when
you...
Okay. Yes. So the original agreement in Madhu Jindal's agreement, the original area is 1200 square feet. So during the course of the construction, the super area increases to 1800 square feet. So basically, Madhu Jindal's agreement provided that the total consideration was 32 lakhs, out of which 24 lakhs was paid. 8 lakhs remained due even under that agreement, which he had to pay you.
For 12, please.
Right? 8 lakhs he had to pay you. Now, the total area of the flat increases from 1200 to 1800 square feet.
Please.
Now, at the rate of 1800 square feet, now he paid, Madhu Jindal's agreement with him was 56 lakhs.
Please.
Out his agreement with Madhu Jindal. You have nothing to do with it.
Please.
They paid her 48 lakhs and 8 lakhs is, but we are not concerned with his agreement with
them.
Right.
Mutual between him and...
Fair enough. We understood that. Now, the point is the para 5
of your lordship's order?
Yes.
Please. The original agreement dated 31st October 2010 was between the first respondent, this is at page 20, Milas, was between the first respondent and the second respondent for the allotment of a residential unit. In terms of the agreement, possession of the unit was to be given within 10 months with a grace period of 3 months. The second respondent entered into agreements to sell with the appellant on 14th August 2011 and 19th August 2011. First respondent had issued a no objection. A balance of rupees 8 lakhs remained to be paid to the first respondent towards the purchase consideration. In the meantime, on 18 June 2012, the appellant was informed that the area of the plot had been increased
flat, right? It should be flat.
From 1250 to 1835 square feet. Since the appellant protested, a new settlement was entered into on 18 June 2012, in terms of which it was agreed that the first respondent would sell the residential unit to a third party and make the payment of 70 lakhs to the appellant within 4 months.
So they were to pay 70 lakhs to you.
They would have sold it within a period of 4 months.
Then you would have got 70 lakhs.
Yes.
They never complied with that.
Yes.
So that settlement fell through.
Yes, please.
So you are now entitled to the entire area of the flat,
Please.
At a contractual rate.
I'm so grateful for those words.
Now, the total area of the flat, we have clarified that the total area of the flat is 1835.
Please.
Now, you have to take the entire flat of 1835 square feet at the contractually agreed rate. Now, contractually agreed rate was how much?
It was 2560.
Kindly have my count.
2560 per square feet.
All right.
So this multiplied by 1835 is that 23 lakhs, 3,000 short of 23 lakhs.
1835, right?
Yes.
1835.
Is about 22.97 lakhs.
Yes, exactly.
Is that correct?
No, my lords. When you divide 1835 into 2560, it comes to, my lords, 46,97,000, my lords.
Sorry, when you divide?
1835 into 2560, my lords.
Because he is misreading his own legal notice. And
No, 1 second. Why are you dividing? Just tell us your calculation.
Please.
The total area of the flat is 1835.
1835.
What is the contractually agreed rate?
It is, my lord, 2,560 rupees, my lords.
Right. So 1835 multiplied by 2560. You said divide. That's why we got that.
It's 22.
How much does that work out to?
It works, my lord. It comes at 46 lakhs, my lords.
No.
वो दिखाओ भाई जरा calculator.
Please have page 75 and 76. I will demonstrate what he is misreading.
We will just do it on calculator. 560 multiplied by 1835 works out to 46.97 lakh.
And that is what they have to pay, my lord. They have paid me only 24 lakhs, my lords. Remaining they have to, besides, my lord, I'm paying them, I'm only asking for a price which was agreed in 2010, my lords.
So 46, at the contractually agreed rate, the total price of the flat is 26.97 lakhs. What has been paid is how much?
24
to me.
24 lakhs.
To him.
To you. So now what is to be paid is 22 lakhs 97,000.
That's what I'm
22 lakhs 97,000 is what you have to pay.
Look, that is their calculation. Your lordship will just hear me on that.
Yeah.
There are two. This matter went through 4 courts: State Commission, National Commission, Review and all that. There are both 2 courts have held this calculation to be incorrect. May I just show that?
But listen, you are in contempt.
Yes.
You have to confirm within the order, my lord.
I'm so grateful.
You have
Your lordship says contractually agreed rate. Please have the contract.
So 1 second. Contractually agreed rate is 2560. We have also taken into account that you are now getting a flat which is of 1800 square feet. Now you can't get a flat of 1800 square feet and say I'll pay at the rate of 2560 for a 1200 square feet flat.
Utmost respect, that's not what I am saying. That's what they are saying. Please have paid 32 for a moment. And the order of the, please have paid 32 the contract itself, and then I will show you lordship the order of the NCDRC. No, the lordship will at least.
We are in the exercise. We are in the exercise of contempt jurisdiction.
I'm conscious.
You have to see nothing but the order of answer.
So grateful. Right? Because the operative portion of the order refers to 2 different documents. Both of them were part of the original record. I'm just showing those 2 documents.
Para 13.
Your lordship will please have page 32, clause 8 of the agreement.
You have to pay the outstanding amount with interest at 7% per annum. We said 7% is on the outstanding sale consideration and the maintenance.
And your lordship quantified at 8 lakhs, and the reason is that page 32, clause 8. Your lordship will please bear with me for a minute.
Page 32.
Please, page 32, clause 8 of the buyer's agreement, my lord.
All right.
If for any reason, your lordship had that?
See.
Yes.
In para 11.
Please.
When the court said the unpaid consideration of rupees 8 lakhs.
Please.
At that point of time, according to you, what was the consideration?
The unpaid consideration.
What was the total? When the court says unpaid consideration, that has to be in addition to something which is to be paid.
Yes.
So this 8 lakhs was the unpaid consideration.
Yes.
This 8 was to be added to what figure?
24. Yes. So because the total value of the flat was 32.
According to him, it comes to.
Yes, please. Yes, please.
Therefore, the difference is for 14 lakhs.
Please.
Right?
Yes.
According to you, you are not supposed to pay this 14 lakhs. He is asking for 14 lakhs. That's your figure.
Asking for, my lord, 22 lakhs.
Just make us understand this.
Just the calculation we had, my lord.
So you are 8 to that 14.
Please, my lords.
Sir?
24.
24.
24 was paid.
24 was paid to them, yes.
So if we add 8 to 24, it comes to 32.
Please.
$24 lakhs.
Our agreement with him?
No, that is, no, that nothing will turn on it, but I will just show that. Miloj, I had on page 48, Miloj.
That is not page number 26.
And what is this clause 8 that you are pointing
Yes,
out?
I'm so grateful. Please.
No, that's the point. That's the only last point we'll consider and then dictate the order.
Miloj, with utmost respect, Miloj, consideration is only one aspect of 5 out of the contempt.
So read that clause 8.
Yes, please. Page 32, clause 8.
Yeah.
If for any reason any changes are required to be made by the sanctioning authorities or by the architects or the first parties resulting in the reduction or increase in the above mentioned areas of the said unit or its location, no claim, monetary or otherwise will be raised. But therefore, in their own agreement, they said whether we reduce the size or we increase the size, we will not change.
Where is your agreement?
Mine was this agreement I had of course adopted and I had entered into.
Where is your agreement?
Page 48. That is
Annexure?
Annexure P4.
Page?
Page 48, Manoj.
No, this is not your agreement.
These are special terms and conditions which I entered because I had adopted the original agreement.
See this?
Please.
Total agreed cost is 42 lakhs.
Please.
Less amount to be paid on possession 0.5 lakhs, 5 lakhs, that is 47 lakhs.
Please.
Balance shall be paid as under rupees 37 lakhs.
Please.
Right? And then it says at the time of execution of sale agreement 4 lakhs, within 2 months from the date is 33 lakhs. So your agreement with him quantifies the total balance as 37 lakhs. Even according to your agreement.
No, just a moment, please.
But let us not go into that, Lord.
We'll not go into it. Look, what we will do is that we'll put an end to the matter. We are exercising contempt jurisdiction, but after all, we are exercising our 142 power also. We will now say this, that you are getting a flat of 1835 square feet, right? In terms of our clause 6 of our order, the entire sale consideration has to be computed on that basis. So you will get your flat, but you pay the balance.
Miloj, would your lordship be willing to see 13 para 1 of your own lordship's order? Your lordship said that their notice has to be in terms of what the NCDRC said in 2022. The NCDRC said that you have to issue the notice you have not asked for an enhanced amount.
But last clause makes it very clear that the price has to be fixed on the basis of the super area of 1835.
But the NCDRC said...
We'll dictate it. Instead of passing a contempt, rejecting the contempt petition, we will just dictate an order.
The NCD...
The
Lordship, may I only point, not on the sale consideration, there are other aspects of which also with there.
Then there is no contempt. There is no willful contempt.
But I'll be left remediless if your lordship will not solve this for me.
That's why we are trying to solve it.
Because sale consideration is only one aspect, Lord. There is another aspect of interest. There is the other aspect of maintenance. There is other aspect of the fit and habitable condition of the flat.
1 second.
Please.
We will ask him to make the flat fit and habitable. All right. That we will do. Where is the flat situated?
This is Ghaziabad.
Ghaziabad, all right. And how much is the maintenance due from him?
Around 6 lakh something.
What your lordship
From
said.
2012 milots. I have to maintain the whole
They
flat.
can't also be quantify some
The
maintenance.
maintenance is not with me, milord, it is with the RWA.
Which there is anybody in the court who stays in Ghaziabad? Any young lawyer staying in Ghaziabad?
Sector 4 Vaishali, milord.
Sector 4 Vaishali. कौन रहता है भाई Sector 4 में Vaishali?
Milord, my client is here. If you can assist with any particular question.
All right, we will say that the order dated 10 October 2022, the dispute in the contempt proceedings relates to the interpretation of the order dated 10th October 2022 passed by this court. Full stop. Paragraph 5 of the order takes note of the circumstance. Paragraph 5 of the order reads as follows. Copy down paragraph 5 at PDF page 35. Next. The above paragraph indicates that the original agreement dated 31 October 2010 between the builder and Ms. Madhu Jindal was for the allotment of a residential flat with an area of 1250 square feet. Full stop. The contractual rate, which was agreed upon in the agreement, was rupees 2560 per square foot. Hence, the total price for the flat was computed at rupees 32 lakhs, of which an amount of rupees 24 lakhs was paid.
32 lakhs was for 1200 milots.
That's what I said. Out of which rupees 24 lakhs was paid, leaving an outstanding balance of rupees 8 lakhs. Full stop. The petitioner stepped in. The petitioner entered into an agreement to sell, dated 14 August 2011. Full stop. Though paragraph 11 of the judgment of this court takes note that the unpaid consideration was rupees 8 lakhs, obviously, this has a reference to the unpaid consideration in terms of the agreement dated 31 October 2010, which was entered into by the builder with the previous buyer. Full stop. Admittedly, full stop. The operative directions which were issued by this court in the order dated 10 October 2022 is in the following terms. Copy down para 13 completely. Operative directions are in the following terms. Next. Reading the above directions in a holistic manner, it is evident that in terms of clause 6 above, the price for the residential flat was to be computed on the basis of the contractual agreed rate and taking the super area of 1835 square feet. Full stop. The contractually agreed rate is rupees 2560 per square foot, while the full stop. Hence, the total sale consideration for the flat on the basis of a super area of 1835 per square foot, 1835 square feet works out to rupees 46.97 lakhs. Full stop. Admittedly, an amount of rupees 24 lakhs was paid to the developer, as a result of which an amount of rupees 22.97 lakhs is due and payable. Full stop. In addition to the above amount, the petitioner is liable to pay the maintenance charges. Now tell us, how much is the maintenance charges?
May I point out the date from which the maintenance charges is payable? The agreement says from the date when the final demand notice is issued to me, and that notice has been issued to me on 3rd June 2022. It is my respectful submission, because there is a component of interest also and the maintenance.
All right, how much does it work out to on 3rd June from
50,000 odd.
From 3rd June
2002, that's the.
How much is the, according to maintenance is payable since when?
It is, my lords, 6,51,000.
No, that is from 2013.
From which date?
from 2013, my lord. Because, my lord, my flat was ready in 2013.
No, but well, he says the agreement postulates that the amount shall be paid with effect from the final demand notice.
Please.
No, my lords.
Where is that condition, sir?
Yes, please.
That, my lord,
One second, please tell us, he'll answer the
That
question.
is at page 34, clause 13, second half of clause 13 at page 34, right and top. May I read?
My lord, impugn order para 7 specifically covers this, my lord. Para 7, my lord.
The first party seller.
The first party seller on completion of the construction shall issue final call notice to the intending allottee, who shall within 30 days thereof shall pay all dues and take possession of the unit. In the event of his or her failure to the possession for any reason whatsoever, he shall be deemed to have taken possession of the allotted unit and shall bear holding charges, maintenance charges, and any other levies on account of the allotted unit. Because this your lordship will find at page 75. He issues a notice pursuant to your lordship's order only on 18th October 2022, wherein he refers
to obviate any controversy on the amount which is payable by way of maintenance to the developer, we quantify the amount of maintenance charges at rupees 3 lakhs. Full stop. The petitioner shall accordingly pay to the developer an amount of rupees 22.97 lakhs, which is the unpaid consideration, together with a further amount of rupees 3 lakhs towards the maintenance, making a total amount of rupees 25.97 lakhs, into brackets rounded off to rupees 26 lakhs.
This would tantamount to modification of your own lordship's order in a contempt petition.
Then we dismiss the contempt petition. You follow your execution remedies. We'll say that. Look, you don't want us to do this. We are doing it to your benefit. You follow your execution.
The benefit that had inured to me in your lordship's original order, at least that be carried.
But our original order says that you are liable to pay maintenance.
Yes, and it says interest on maintenance also.
Para 7 minutes.
Because your lordship says interest on maintenance. Maintenance is 50,000, interest is 2.5 lakhs. Your lordship will at least, I've come in a contempt, at least I should not be put at a disadvantage of what the benefit that I've got.
Okay, you have come in contempt, should we dismiss or you withdraw? And then you take the recourse available to you in law. One word, yes or no. You have devoted 30 minutes.
I'm conscious of that.
With a view to see that this helpless man is being given something. He has purchased a flat. Now speak to him. Speak to him that this is what has fallen from the court. Discretion is the better part of the valor, my friend. Don't get into any further controversy. He's a builder.
Page 21.
He's a builder. He'll harass you like anything. So this is the final order. Accept it and tell your client by what time he will pay this amount.
Your lordship in the original.
By what time he will?
At the time of conveyance deed, as indicated in your lordship's original order.
Fine.
Within 2 months.
Within 2 months? Hence, now the quantum of interest will be computed on this amount of.
Because your lordship's original order said interest on 8 lakhs. Now your lordship saying interest on 23 lakhs. But if I press this, then your lordship asks me to withdraw the contempt.
You can execute the order then. Execute the order.
Executing court will also have a problem in interpretation.
See, we have said the interest at the rate of 7% per annum as noted in one above shall be payable on both the component of the unpaid consideration of rupees 8 lakhs and the outstanding maintenance charges.
Therefore, I'm with utmost respect, I'm saying your lordship says 8 lakhs. Please don't make that 8 lakhs 20.
All right. He will pay 7% interest on the 8 lakhs and he will pay the maintenance charge and on the maintenance charges. He's right. The 7%, taking a strict view of our order, the 7% maintenance is only on 8 lakhs, 7% interest on the 8 lakhs and the unpaid maintenance charges of 3 lakhs.
And your lordship will also now indicate interest starts from which date, because he starts from 2013, I start from 2022. I am sticking to the buyer's agreement.
Should we quantify the interest in the lump sum so that will also come to an
I've done so in my reply to him.
para number 7 of the order, my lords, it is very clear since 2012, my lord, he was not coming to me. He was claiming refund, my lord. Considering his conduct, my lord, I should have demanded notice, my lord, for 24%, my lord.
Yes, and then we turned down and 7% has been granted. My friend now wants to rewind the clock way back to State Commission.
Order is very clear.
Just clarify this. In terms of paragraph 13, bracket 2 of the order of this court dated 10 October 2022, the interest of 7% per annum will be payable on bracket 1. The unpaid consideration shall be paid on bracket 1 an amount of rupees 8 lakhs, which was the balance payable to the previous balance payable by the previous purchaser, semicolon, and bracket 2, the maintenance charges which have to be paid. So stop. The maintenance charges.
We have no way to go with this, my lord. I am giving you a flat at the rate agreed in 2010, my lords. Now it is
all right, but we have to also, we'll strictly construe. Our order at 13.2 says the interest at the rate of 7%, as noted in 1, shall be payable on both the component of the unpaid consideration of rupees 8 lakhs, we have said.
That is why, my lord, court has specifically recorded that the area of unpaid consideration is 1835 square feet.
For the purpose of interest, we have said that, we have drawn some balance.
Kindly appreciate, my lord.
Or shall be payable, वो तो लिखा ना, interest on maintenance. ऐसा लिख लीजिए, the maintenance shall be payable with effect from the date on which the developer had issued a final demand notice and offered the flat for the purpose of possession.
Being 3rd June 2022.
Being 3 June 2022.
For that, Lord has to read the order 7. Para 7 specifically records that.
That's okay. The contempt, the developer is given a period of shall render the flat fit and habitable in all respects for occupation on or before 30th November.
It is ready, Manoj.
30th November.
Your Lordship, in the original order, had said
the conveyance shall be executed no later than by 7 December 2024. And payment shall be made of the balance in terms of the present order at the time of the execution of the conveyance. So we've brought about some balance now. We are giving you the entire consideration on the basis of the overall value area of the flat being 1835. We have given them some benefit in terms of the maintenance. That's all.
Please, just so that we don't have to come back. Your Lordship has said 23 lakhs of the flat, 3 lakhs of the maintenance, and interest to be calculated at 7% on the principal amount of 8 lakhs from 3rd June 2022 till.
No. We have said that interest has to be calculated on 8 lakhs.
Yes.
That's from the original. But interest on the maintenance shall be computed from 3rd of June 2022. But the 8 lakhs you are liable to balance.
Not that 8 lakhs to be.
That itself would amount to another 17 odd lakhs.
This is not 8 lakhs, sir. Balance you have to pay is 23 lakhs, as we have said in our order.
Just from my understanding, Lordship says 23 lakhs as sale consideration purely.
Yes.
Second, your Lordship says maintenance, your Lordship has quantified at 3 lakhs.
3 lakhs.
Now the third component is interest.
Yes.
Now interest is not payable on the 23 lakhs. Is that correct? Because your Lordship has already given him.
Look, because whatever we say in terms of from what date there will be another dispute, yes. We quantify the interest component.
Please, your Lordship, as per 3.
Look, 1 second.
Yes.
We will quantify the interest component. We will say that the interest component, how much according to you is the interest?
Your Lordship has said.
The problem is that you are such an obstruction in the resolution of this matter. Honestly.
Because I am pointing out your Lordship's order to yourself,
We'll just dismiss it. We'll just say there's no contempt, there's no willful contempt, because there's so much of interpretation which is required. You execute the order and let your client be.
Because your lordship will indicate that also.
Yeah. You're giving us gyan now that you're only relying on our order. We find no willful. We find no willful disobedience of the order of this court. The contempt petition is dismissed. With liberty to the petitioner to apply for execution before the NC trial.
Would your lordship be so kind enough to accept my apology?
No. Sorry.
If
you start giving us gyan, then we will also do what is. We will go strictly by the law. There is absolutely no willful.
Word was not appropriate.
Please learn for the future in some other case. Yes, second.
Would your lordship give me an opportunity to learn today?
Matter is over. Seal number 2.
Would your lordship give us an opportunity to learn?
Seal number 2.
I'm so sorry.
Just a second. Seal number 2. You 1 second. You go outside, Mr. Developers Council. You both go outside. You solve the matter between us. Give us an agreed term. If that is so, we'll.
I will bow down to whatever your lordship.
We do not talk to the developer's lawyer now. Sit down. Come with consent terms in 10 minutes. We'll pass an order. We don't want to do this at all. You spend half an hour. At the end of it, we are given some philosophy of some lawyer. Please go and talk to him. Settle the matter and come here. Otherwise, we're dismissing the petition.
We'll do that, Manoj, and I'm extremely sorry.
Yes. Item 2.
So, Ms. Bhatti is leading us in this matter, Manoj, sir.
With my lord's kind permission, Manoj. Manoj, on the last occasion, and I don't think the Geeta Mittal committee has a quarrel with it, what we were suggesting is a subcommittee be formed under Geeta Mittal committee.
For what actually?
Because there are several hundreds of students. Many are in relief camps. Many have been.
Approached us at all.
There are several students. Many are in relief camps. Many have left the state. Some have abandoned education. So what I found is that it is an overwhelming responsibility, which it will not be personally possible for the committee to carry on. So some committee under the committee of Justice Geeta Mittal, if that can be constituted, they can get into the nitty-gritties. For instance, when students are asked to be accommodated into
how many students are there actually?
I'm finding here, Manoj, like there are 284 students of Manipur University. They have discontinued. 93 have moved out to Delhi. 159 have moved to West Bengal and 3 other states. They are all trying to get back into the
Ms. Bhattija, perhaps Justice Geeta Mittal, because instead of us going to the facts of each individual.
Already considered. In fact, I don't know what Mr. Paul is referring to. In fact, if he's referring to BCom final year students, your lordships, those lordships on the last occasion had asked them to approach the committee. The committee has considered your lordships in report number 37. The case with regard to undeclared results of BCom final year students at Jury University. And then your lordship.
Has Justice Geeta Mittal issued directions and have they been rehabilitated?
Because there are issues of.
Already, Advocate General of Manipur is here. Now you tell us this, how many students have been relocated in other universities?
I don't have the exact figures, but with respect to submission of the Senior Counsel, Mr. Paul, the committee has done a pan-India extensive exercise involving the Legal Services Authority of each and every state. In one of the reports of the committee, in fact, each and every Legal Services Authority was mandated to reach out to students who were displaced from the state to any corner of the country.
Right.
In fact, there were 3 nodal officers who were set up by under the orders of the government, and the government, in fact, unfortunately, have not received a single representation from any of the displaced persons. These were the instructions as of 2 months back. Now, in that scenario, I fail to understand how my learned senior is saying that these many people are still aggrieved. And that's the first point, I would like to submit. The second point is, the committee, after the direction which was issued by this Honorable Court on 9th of August, had convened already 2 meetings wherein the grievances of students of Manipur University has been addressed. As of now, in the current grievance which has been raised by the interveners, in fact the applicants after the matter was displaced, administrative issues, there are about 10-15 administrative issues. The rest were asking for transfer of. They were asking for transfer of.
We asked Justice Geeta Mittal to look at, give us an update.
My lords, if my kindly.
If my learned friend will just hold on for a minute, Your Lordships. In fact, there is a complete chart of each and every student. Now, some of them have only administrative issues which have also been resolved. The registrars of the universities have been given the procedure. They have been told who to approach in the universities. Now, the only thing that is left, Your Lordships, is with regard to transfer. Now, transfer as far as the university where they're already studying, those universities have given NOCs. However, the recipient university cannot accommodate them.
Is there a report by Justice Geeta Mittal? Yeah. The updated
37.
Just give us the 37th report.
My lords, if I may interject, my lords, in terms of the grievances that were raised with the committee as well, my lords, they've categorically at least explained to us that transfer cannot happen, which is why we were at least acceptable to the fact that in terms of the administrative issues of allowing the students to continue online classes, my lords, that till date, post the August meeting, 2 meetings we've had with the committee, of which these administrative issues still have not been resolved, my lords. And this is specifically with.
We'll keep it after Diwali. We'll just tell Justice Geeta Mittal to, because she is monitoring all individual cases, we'll just ask her to give us an updated status report. Then we will see if there are any further directions, because Justice Mittal has sorted out most of these issues.
In fact,
not at all resolved, my lords. I beg to differ, my lords. In terms of my note which I've circulated.
Sir, we'll ask her to submit a status report to us. If there are some directions required by us to the authorities, we'll issue them. But we must at least know, because frankly, we are at a loss to understand what directions we are required to give. Let that learned judge whom we have appointed to oversee the committee tell us what directions are required now to effectuate.
What we are saying is, I wanted to make my learned.
We are not going to constitute another, Mr. Paul. We are not constituting another subcommittee. Justice Geeta Mittal is in charge. Let her handle it. She has nodal officers who report to her.
With due respect, Madam, I'm not asking for a parallel committee. Somebody under her, so that the nitty-gritty of issues.
Let us say that. Let us say that to us, that she is not able to.
Because doing them themselves.
There are 3 of them: Justice Joseph, Justice Asha Menon, and Justice Geeta Mittal. And the nodal officers are reporting to her.
And they are having video conferencing on 15th of
August. Just say the chairperson, Justice Geeta Mittal, chairperson of the committee appointed by this court, is requested to provide an updated status report on the status of the students who are pursuing their education in Manipur in different universities in regard to their transfer, in regard to their transfer, right?
Transfer. It's by and large transfer.
To other universities. Good stop. This may be conveniently provided within a period of 2 weeks. This thereafter.
They may
my lords.
Give a copy of that report, my lords, on the last occasion.
Last occasion.
What were you saying, Ms. Makira?
Lordships, what would be required is for the central government to respond to our report, because it's with regard to the transfer and the regulations with regard to the seats. So Lordships will incorporate that.
A copy of the report shall be served on the standing council or the on the council appearing on behalf of the Union of India.
Union of India. Ms. Bhatti is appearing.
On Ms. Bhatti.
Yes.
Then ASG appearing on behalf of the Union of India, so that India can apprise this court of the further steps which have been taken in that regard.
My lord,
you must read the reports which are available.
No, may I, with my learned friends.
We have other matters to get along with. We have asked for a status report.
The only thing is a copy may be supplied. That's all.
We just said that.
If my
Item 3, we have already stayed the order.
Please,
we'll have to list it on a non-miscellaneous day. 4.
Item 4. Published.
Other matter was which they had filed against the execution is listed on Friday, and they had also indicated while appearing before your lordships that the same would be filed, the second one would be filed, which is listed today. So would your lordships have it on Friday also? Because I've also not got a proper briefing in this.
In this matter?
Yes, so.
All right, we take both matters together on Friday.
No issue.
Report better. Yes.
No issue.
Yes. Great.
Just a second. With your lordship's permission. With your lordship's permission, my lords, may I tender my unconditional apology in
Get the other side now. We get the other side. You can settle the matter and come back to us with a.
He's indicated that he will not be, until the matter is called out, he will not be coming in court, my lords.
So tell him the matter will be called out now in the afternoon. Call him at 2 o'clock.
Please, grateful.
You know, we tried.
The contempt, it's contempt. The contempt petition. Confirm that both members are there, right?
May please.
I guess. Yeah. After.
Lords, I think it's my duty to tell your lordships, based on the material that I've placed, that it will take a little while. Just want to clarify. There are two binders. Both have been placed.
How long would you take? About an hour or so?
No, Mala, that's with the amount of material that has been placed, it will take about a day. It is a substantial issue, and I don't think, Mala, my conscience will not permit me to try and stifle it, because there is much to be said. There are 18 notes to compress everything else, because the judgments and the documents that have been placed on record.
What is your assessment, attorney?
On ours, I'm sorry.
No. I asked Mr. Solicitor.
No, I'm sorry, but then, my lord, I can definitely answer.
Sit in the middle, Solicitor.
No, my lord, I requested her that let me, anyway, my lord.
I'm will ask Mr.
My lord, so far as we are,
too far, Mr. Mehta.
my lord, we are, so far as we are concerned, my lord, the ramifications are very long, my lord. It is not our case that one can have sexual intercourse without consent. Autonomy respected, consent respected, but it's a polycentric problem. Your lordships will have to, my lord, examine several aspects. I would also, my lord.
How long would you take up here?
About a day, my lord. That's my assessment, my lord.
And Mr. Dwivedi?
About a day, my lord.
So you're talking of about 1 day for you, 1 day for Mr. Mehta, and 1 day for Mr.
Mr. Marinder Singh is appearing, and Mr. Datar is also here.
But I would also
is also appearing.
My lord, I would like some clarity whether I am expected to address the court after Mr. Gopal Sankar Narayan, which is what was indicated on the last occasion. Because I am also arguing that charges can be brought under the existing provisions and I need to be heard.
But then that's a separate issue which will have to be dealing.
Indeed, it is not a separate issue, my lord. It's a connected issue. This is what I have been told for the last 1 year. Every time this matter has been mentioned, I've been told that the two matters will be heard together. Indeed, there's a single judge judgment of Justice Pardiwala of the High Court of Gujarat on which I'll be relying to substantiate my suggestion that there can be prosecution under the existing law. To the best of my ability, I will convince you.
Notwithstanding the...
Yes, my lord. As your lordship,
but therefore,
on a demerit.
But therefore, you're not really on the constitutional validity.
My lord, the two overlap without any doubt.
And I have been told for the last 1 year that I will be heard along with this case.
Ms. Jaising is right. There is an overlap.
All right.
Where
Then
we demonstrate.
you are taking about a day.
Yes.
Ms. Jaising, how much time will you take?
It would also take about a day.
So that gives you 2 days for this side to complete. And how long would
Half
Mr.
an hour,
Shankar?
not more than that.
About half an hour. So we can ask Mr. Shankar Narayan to subsume you within that day. And Ms. Jaising says she'll take a day. That is 2 days. Then Mr. Solicitor says he will take about a day. And Mr. Dwivedi.
I would respectfully, Lord, most humbly, Lord.
You are saying about a day for yourself?
Yes, Lord, but I am submitting with utmost deference, Lord, and Lord may not take it otherwise, Lord. This matter, Lord, may not finish, Lord.
So we were then thinking how much time we
Mr. Dave is also there, Lord.
No, Mr. Das.
Cutting too fine.
Dave is there. Mr. Maninder Singh is there.
Yes, mine only.
Test an alternative. My lords, written submissions.
Unless we finish the hearing this side of the vacation, there's no question of us delivering judgment.
Exactly, my lord. Exactly, my lord.
True, we would love to, but realistically, my lord, it may.
Then we would have got the Diwali.
I thought,
My lords, written submissions have been filed by all parties many weeks ago. Ms. Jadeja has also received.
that's why I wanted to indicate at the outset, rather than start it and then be.
Right, and then
But my lords,
say that we have heard submissions on behalf of the petitioners by Ms. Karuna Nandi, Learned Senior Counsel. Who else argued? Mr. Karuna.
Mr. Gonzalez.
Mr. Collins Gonsalves, Learned Senior Counsel. To stop. Mr. Gopal Shankar Narayan, Learned Senior Counsel, states that he would require approximately 1 day for his submissions. To stop both the learned solicitor. This will be followed by the submissions by Ms. Indira Jaising, which, according to the Learned Senior Counsel, would take about a day. Full stop. The Solicitor General, the Learned Solicitor General, and Mr. Rakesh Ved, the Learned Senior Counsel, have both indicated that they would take a day each. Full stop. In other words, on the estimates which have been provided by Learned Counsel appear, Mr. Saidip, how much time? 1 hour. But then it's the subsumed with.
2 hours for me, my lord, for Purusha Yoga, my lord, I am in the intervention.
That's right.
Mr. Siddharth.
The interveners are not going to.
We have conducted a study on 59 countries across the world.
my lords, this exercise my lords had done at the
The
outset.
above estimates, the court would be required to hear arguments on behalf of the interveners as well as Mr. Siddharth Dave for the contesting respondents.
He's for the petitioner,
For the petitioner
in the first matter.
companion.
He's for the accused, rape accused, my lord.
He is a respondent.
In view of the time estimate, we are of the view that it would not be possible to complete the hearings in the foreseeable future. Full stop. Therefore, we direct that the proceedings be listed after.
My lords, we have a request. My lords, we have a request. My lords have always, my lords.
Regret, because I really wanted to continue here.
Obviously,
I have to tell you in fairness.
My lord, may I just be very, very briefly considered on this point? My lord, I had pointed out that the decisions that my lords have yourself made in a number of judgments, not just Joseph Shine, but independent thought and others covers the field, my lord.
That's your submission. We can't prevent everybody else from arguing.
They're all distinct.
But my lord, we stick to the court discipline, and in fact, if everyone coordinated and ensured that the same discipline was kept, it can, my lords, this matter can definitely be finished by Friday evening.
Apologies for the indiscipline.
So, my lord, so, my lords, indiscipline aside, I mean, this is also the urgency my lords have held repeatedly.
As the last counsel in several important matters and been very, very precise, given us very precise submissions, even the learned Solicitor General and Mr. Devedi will accept that, in 370 and all.
This is not personal about anyone. This is about the millions of women around the country, my lord. Who, and my lords have recognized the urgency, and my lord, you have yourself.
The lawyers say that on both sides we have to hear argument. When everybody says you're going to take 4 days.
Being happy in saying that, but that's
push it beyond.
But my lords, most respectfully, your legacy in all of these very important judgments, this is what will bring it home, my lords.
to the millions of women around the country.
So we will keep it now after.
This is the case that will bring it
They want to, everybody wants to argue.
But I don't want to join issue on this, but your lordship's legacy would remain, my lord, forever. Let us not ridicule it by saying that judgment
That is certainly not what's happening. We are talking about this case. We are talking about this case.
And
after 4 weeks.
I'm good.
My lord, in that case, if I may be permitted to expand on my arguments, and I will take another, not more than 2 or 3 hours.
You tell that bench because it's a fresh bench. You can re-argue.
No, so it just may be mentioned. It just may be mentioned.
It has to be re-argued.
I'm very clear.
Fair enough, man.
I'm very clear about how it should have started and how it should have gone, which is why those massive compilations were necessary. I'm grateful, man.
We'll begin on the next occasion. All right, my lords. Thank you.
please.
My lord, I'm really sorry, my lord. Just a question, housekeeping question, my lord. This matter has been adjourned. May we just have a date on which it can be possibly?
After 4 weeks, you have said it. It will be listed
Because
exactly after 4 weeks.
especially as far as I'm concerned, my lord, there is a stay operating against me.
So we have 4 weeks.
Yes, my lord. It doesn't matter, my lord. From speaking for myself, I'm happy to appear before any bench, and your lordship may just give a date. That's all.
4 weeks.
Obliged.
(101) I did not mention because I thought that this will go on.
What we do?
Part third matter, my lord.
No, we'll just take the next matter on board. We'll start the next matter on board.
My lord, there is one difficulty, my lords.
5, 6 are over. 7 is the restitution. Then the conjugal rights is really dependent on that. That can also go after that.
It will have. The reason is this.
Lord,
There are
complete submissions. Everything is in a place. I can finish it off.
Sanjay, I'll just.
After vacation.
My lord,
After vacation.
my lord, there are other than Hindu marriage, other laws are also challenged.
Push that also.
Wherever
Because these are
reply-
they are both interlinked.
They will have
at least constitutionally they are interlinked.
Constitutionally, not
on provisions.
consequence wise, but constitution.
Manoj,
We'll take some
I think I think, my lords, I would be able to satisfy your lordships within what is allotted to me this day.
We'll take up item 8 now.
I wasn't there at the time and I'm very sorry, my lords.
No problem. Item 8.
My lords, in item 8, I am appearing in 8.2. This is that royalty matter. We are led by.
Can also come back.
We are led by Dr. Singh. Yeah, and Mr. Dhruv.
Anticipating that the previous matter.
We didn't expect, to be honest, don't even have a.
So we come back after lunch. We are just 15 minutes short of lunch. So everybody has a time to regroup and
take it tomorrow, Manoj. Actually, I'm in the midst of apartheid, but I'll leave it to you, Lordship, Manoj.
Just apprise us at 2 o'clock, whenever you people want it. So if it has to start and has to open, then we'll take it up at 2 o'clock. Otherwise, then we have item number 9, which is the ERA matter.
11, ERA Malot can go on, but 11 is old pension scheme, new pension scheme.
Yeah.
Where the learned AG is not there. Both of us are appearing, Malot. I must tell you, Lordship. Can be kept on 3rd, Malot? 11.
We have 11. We have the. We'll go serial that we can see what opens.
Item 8 will be at 2.
Yes, we are present. We are rising now, so that you people have time to regroup and tell us whether you want to go on with 8 or then if 8 doesn't go on, then we have to start with.
Well, I think we are ready to go on, well, subject to my Lord's pleasure.
All right, then just tell us if both sides are here, we'll take it up and give us an estimate of how long it will take.
Yes.
Obliged.
Obliged.
for marital rape?
Yes.
Yes, Mr.
Well,
Devi.
there's one objection, Lord. It should not be termed marital rape because it's not rape as yet, Lord. It's a marital exception matter.
Yes. So what are we now? Which matter you're mentioning, or you?
Item 8. No, we are ready.
Item 8,
Lordship,
8.5.
Other side.
sorry, I wasn't here when item 8 was called out. I'm for the union. We're seeking some time, my lords, to file the counter affidavit. There are civil appeals as well as there's a writ petition.
Whatever now there is on the record, we'll hear it. We have given so much of time to the union to file.
It's in the writ petition notice.
The entire controversy. I mean, I remember reading this at admission. Now I don't even.
It's a
I don't need
royalty issue.
But it's entirely on the turns on the interpretation of the law. Actually, there's very little factual.
The Lordship may just give me 2 weeks to file the
Start.
department's.
We'll start this. We have made
Because
it
your
clear.
Lordship, there's a
And you know, this group of matters has been on our board, I think, for the last 2 to 3 months.
Yes,
So,
Lords,
number 1.
which is why the counter.
we've had
pending
how many
approval.
matters above it we have disposed of? We disposed of Chola,
This is number 1.
Canon, Jet, Viju. We started, I don't know how many other matters we disposed of.
Which the counter is pending approval. That's all for
You can-
filing.
That's okay.
And
And
the
come with the counter, no
In the
difficulty. you can
connected
file.
writ, the notice was issued only on 2nd of September.
No, well, it's the
That
same
was
issue of law. Now, well, let me make it very.
Let's understand what the conflict
Yes, that's all, Malas.
No, I'm in the first matter, Malas, which is some different from my learned friends.
I'll make it clear, Malas. 8.2.
You are in this Salito Oars versus Captain of Force and other.
I am asking your lordships to take up 8.2. The matter is common.
Between
8.2
you and Mr. Dwivedi, you decide which matter is.
Where-
Why do you leave it to us to start?
Very well. I said we're a subset. So here's the shorter point, and then there's a larger set. That's all. I was only on the. We are on royalty. Mr. Dhruv Mehta and Mr. Dwivedi have the larger issue of ASP also. That's all I was saying.
We leave it to your lordship, whichever matter.
All right. Yours is a smaller issue.
Yes, which is common to all three, of course.
Oh, I see.
They have additional points.
They have additional points.
Yes. Therefore, well, I'm only saying this, and I'll make a note to shorten the time, and the lordship is hard pressed for time. So
We'll be also dwelling on what Dr. Singhvi has
I will
argued.
not be dwelling on that at all. No. There is a different
Additional
point.
point.
Different, entirely different.
Oh, I see. Broadly, just without going into it at any great length, can you just, Mr. Dwivedi, tell us what is the issue in your case, and then Dr. Singhvi in a minute, just what is your
In
case?
my case, the issue is this, that a notification was issued by the central government under section 9(3), altering, which enables them to alter the rate to a
royalty.
Right. So they issued a notification. Earlier, it used to be tonnage basis.
Right.
They changed it to the sale basis.
Right.
Now, sale price basis, 10% of the sale price. So our first submission is that 9(3) specifically says that you can enhance or reduce the rate. So the expression enhance and reduce doesn't mean, that you can alter what Parliament has fixed in Schedule 1. You can jack it up to 12%, you can reduce it to 7% according to your policy. That's the first point.
And this enhancement is done by the
Central government by notification under section 9(3), they have completely changed.
And what is prescribed?
This
This is prescribed by Parliament.
Yes. This is
Your intention is that the words enhance or reduce.
What is the scope of this?
Change the basis of what Parliament has specified. That's the point.
That's the point. The second point is that along with this, concomitantly, they alter the rule. And by rule, they say that IBM will fix the sale price.
Who will fix it?
IBM.
That is the Indian
Bureau of Mines. So, which is subdelegation to another authority to determine the price. There cannot be a subdelegation which is not contemplated by section 9.
Oh,
the third point is that the Bureau of Mines adopts a unique method which is called weighted average price of the top 10 miners, non-captive. So the result is that my sale prices are varying between 200 and 300 per ton. Now the other miners, which are non-captive, rates goes up to 4,000, 3,000.
And their rates are taken.
So they are not even taking the actual sale price.
So these are the 3 points.
These are the 3 points.
And Dr. Singhvi, what is the point?
My point is none of these points, Wallace. The Point is a narrow point.
But you were saying you are a subset of Mr.
Yes,
Trivedi.
subset, because at least I know Mr. Dhruv Mehta was the same thing, the same subset. You are in the process of calculating ASP, average sale price. You are including royalty in the last month's ASP, then calculating this month's ASP on the basis of the last month's average, which includes royalty, and then again imposing royalty. So mine is the pure royalty upon royalty compounding issue by explanations. That's why that issue is a very narrow issue.
Narrower issue.
That's what I'm saying. And I am challenging only the two explanations.
With your permission.
Mr. Dwivedi is same. Dr. Singh, we'll hear it briefly because that probably will. How long would you take, Dr. Singh?
I will try to finish within half an hour. I made a note. I'll read only half of the note.
And on the other side, then we will hear this.
Lordships, if I may.
A batch of matters here tagged together. Deal with the issue of notional price fixation.
Are your tag matters with Mr. Dwivedi's matters?
Yes, Manoj.
All right, then that's all right. Dr. Singhvi has a very narrow point. We'll take that and then we'll start with Mr. Dwivedi's matter.
First finish this matter and then take up.
And then we'll take your case.
We are also arguing about the priorities of Rule 64D. The High Court has discussed that, so I'll be very concerned.
Lordships, if I may, there was a Ministry of Mines committee that was constituted to look into this issue of double calculation of royalty. Your Lordships may just permit the department to place the counter on record. At least I'll have some
instructions. Because this may not get over today. You can place the counter on the record. That's not an issue at all. If you find any difficulty in filing the counter and there's some material you want to place, we will not stand on any technicality. You can place any report, any material. We never stop the government from placing relevant documents. There's no difficulty.
And this recommendation she's saying is what I'm relying upon. It's there on the record in my
case. Let us see now how it arrived.
This is likely to take some time, my lord. And rest of the matters.
Which one are you in?
I'm in 11, my lord. That old pension scheme, new pension scheme for the judges, my lord. There, the learned AG and me both are appearing. If that can be kept on 3rd or 4th.
We'll hold it because tomorrow is Thursday.
Yes.
A lot of judges are waiting in the queue. So maybe after this matter, we can take it up tomorrow, solicitor. So
that is different, my lord. Your lordship. So that, of course, I'll take instructions. Lord, Rajasthan and Madhya Pradesh. This is regarding old pension scheme and new pension scheme.
All right. There's also some issue about, let's keep it for tomorrow. We can, even if you have some suggestion, the government can consider the suggestion. So we can at least, only because it pertains to pensions for the district judiciary. People are waiting in the line, for a long time. So
but 11 is slightly different, but we'll let it be tomorrow. We'll explain the list.
All right. I think between all of you, you're good for today at least, I think. You're safe today, actually, not to be called out today. We'll discharge the rest of the work. All right. Yes, Dr. Singhvi.
Same request by recommendation. Item 10, it's a priest matter
because the tax should be deducted at source on salaries which are paid to priests.
Because our short point is there are circulars from 1944, and without withdrawing the circular, you can't tax.
One by one, will be dedicated.
TDS will not be deducted.
No, there's a board circular which are not withdrawn.
All right.
1944, the
Mr. Datta not to be called out today, of course. Now we are good for this matter.
Then after,
you are here tomorrow?
I'm here tomorrow.
Yes.
Then we'll see tomorrow. If it reaches, we'll take it up tomorrow. But uphill case for you to.
No. I have no issues. I am submitting there is a board circular. Unless the circular is withdrawn, you can't. They can no jurisdiction.
Merely because you are a priest, how can you say that there will not be?
No, because Article 25, I've taken the vow of poverty. I don't have a bank account. I can't keep any money. I can't have credit card. No, I'm saying it's a very unique.
The money is accrued to you as a priest.
No, it can never because I've renounced the world. The canonical laws are there.
Anyway, 9 will come before 10.
And I succeeded before the single judge.
Directed it.
Right.
It's after this.
I succeeded before the single judge.
We'll start. All right, tomorrow we'll see. This is all over. This is just an prima facie conversation. When the matter opens, we'll apply our minds.
Till the electronic system came.
Later. Yes.
Till the electronic
Item 8.
Till the electronic system came, the entire money from the government went to the diocese, and the diocese pays tax. The diocese, they are charitable, so they are taxed under 11, 12, 13. So not the individual priests. Not that they exempt from tax.
Right.
Okay. Yes, Dr. Singh.
Let me just take 2 minutes to explain the concept. It's a very, very narrow issue. And then I'll hand over the note. Now, the concept is this. To levy, Malaj.
Yes.
To levy Malaj royalty, you have to have a base price. So ultimately, Malaj, they said that we will take I'm just giving the concept.
What are you doing exactly?
IML is mining iron ore. This is an iron ore case.
Iron ore.
Iron ore. Now to levy royalty.
So you have been granted lease.
Yes. Mining lease.
To extract iron ore.
Iron ore. The only issue is how do you calculate royalty? That's all.
How do you calculate royalty? Okay.
Now, why that is an issue is because we say in calculating royalty, you are calculating royalty upon royalty and monthly compounding it.
Because according to you, the royalty has already gone into the ASP of the previous
month. Exactly. That's the one sentence, that's the whole case. Let me explain only just a few more sentences. In one sentence, that's the case. Why they do it, Police? They have to levy royalty. So what they do, and that is the part of some of which Mr. Dhruv Mehta or Mr. Dwivedi may be challenging. I'm not concerned with that.
But on 8.1, right?
8.2 is my file. 8.2
So
is my file.
all the relevant documents will be in 8.2.
Yes, we have it all.
Yes, but or either I'll do that or I'll maybe refer to one of the documents of Dhruv Mehta's file. I will not go outside.
And difference, my lord, because Dr. Singhi is presenting on the new rules. We are not by appeal.
But there's no difference.
Which are right.
It pertains to the previous.
That's the difference.
Which we have said.
You are Mr. Mehta in which matter?
8.3, my lord.
8.3. All right.
Also, this matter also.
We'll bear this difference in mind.
And your lordship, basically, one of my points I'm making up. In substance, the old and the new are identical.
All right.
Anyway,
Now,
forget that.
just explain now how it arises.
So, whereas the state to calculate it takes state-wise. So, in the state, suppose you have 10 players. They take the weighted average of the sale price of those 10 players. Somebody sells more, somebody sells less. In the month, let us say, last month.
What Mr. Dwivedi was saying also.
Let us say the month is, let us say, September. So, September, the weighted average of those prices is 10 rupees.
The top 10.
No, they take a weighted average system, which is basically a top 5, 7, maybe some other player, but the weight makes it all right. Well, suppose somebody produces 100, the other produces 10. They're taking the weighted average. So the 100 fellow gets a greater dominance in that calculation. So there's no problem on that. That ASP is arrived at a 10 on the basis of the average sale, is called ASP.
What is ASP?
Average sale price, which is nothing but the weighted average of the price which these 10 players are selling at.
Yes.
Your Lordship may assume that the universe started in month 0, September. That's not true, but Lordship may assume that. You have to take a 0 for a minute. So it starts there. That is the average. Now in month 1, which is the month after the next one, they take, in the month 0, you've calculated ASP. On that you pay royalty. That becomes the base for paying royalty. So in month 0, you have paid 100 plus 10, 110 rupees. Which includes 10 rupees as royalty, calculated on 100, which is ASP. I hope I'm clear till now.
Yes.
Now, in next month, you take 110 and again calculate royalty, which obviously includes the 10 royalty of the previous month. And so on and so forth on a cascading repetitive effect. That's the concept. Just give me 2 minutes more.
And then we'll see the actual rules, how it works.
Yes. This is done. In my, there is a regime which is pre-2015. There is a regime post-2015 amendments to the Act. In our, according to our submission, not necessarily me to go into it. The two are on this issue the same. Concepts are the same. But I am technically under the new regime, post-2015-16. Now, what happens is, when you levy 110 plus again royalty on 110, then the next month on the 115, etc., etc., it has a huge cascading effect, with millions of tons involved. Now, this is brought about by 2 explanations. One to Rule 38. I'm now talking only of my regime, which is the new regime. According to me, in substance, the numbers will differ, but it's the same in the old regime. But I'm not getting into the old regime. I'm making it simple for my notebooks. Your Lordship has explanation in Rule 38 and also explanation in Rule 45 bracket 8A, right? It's only these 2 explanations which are interpreted and applied to mean that you can and will charge royalty on royalty. We therefore challenge these 2 explanations. 45(8)A is of MCDR. That's my limited challenge. 45(8)A
8 capital A, right?
is of the MCDR Act, not the MMDR Act. Oh, sorry, rules. MCDR R stands for rules.
What does MCDR stand for?
Mineral Conservation
and Development Rules.
Mineral Conservation Development Rules 2017.
First one is a mineral concession rules.
And the first one is MCR, Rule 38 MCR, Mineral Concession Rules. And that's the challenge. My whole case is limited to explanations on these two matters, which I am challenging.
MCR is of which year?
2016.
To 2016 was. And MCDR is 2017.
Right.
Now, the other interesting point here is that two facts I should know at the outset, which makes it simple. Your Lordship knows, brothers, that there is quaintly from old times, because coal had a special place in our country. We have two ministries. The only anomaly your Lordship find that Government of India has two ministries. One is called Coal Ministry and one is called Mines Ministry. So coal is put in a separate ministry, mines is put in a separate ministry. Mines means everything other than coal, including I'm iron ore. This whole batch is iron ore. So, brothers, quaintly two striking facets. The Ministry of Coal, which is a counterpart ministry and an identical concept, the mineral may be different. By a notification on 14/7/2020,
Amendment to the schedule to the Act.
which notifies an amendment to the schedule to the Act at page 147, which I'll presently show, PDF page 180.
Ministry of Coal notification will be 14/7/20.
Yes.
20 regarding coal. At Wallace.
Just one second. Ministry of Coal.
Notification dated 14/7/2020. Kwe coal.
14/7
July 2020.
2020.
Kwe coal, which is at page 181 of the PDF, clarifies that the sale price, again you calculate and apply to coal, the same system I told you, Lordships, shall exclude royalty month on month on month. So the next month's price of, the next month's calculation of royalty will be on the previous month's, on the previous figure minus royalty.
Right.
It clarifies in writing statutory, I'll show that in a minute. Number two striking facet is, following upon that, and after over 6 months of examination, on 25 May 2022, just keep checking it. The other ministry, my ministry, the counterpart Ministry of Mines, issues a public consultation detailed note expressly saying that for all other minerals also, you must avoid the quote unquote cascading effect unquote of royalty and the other concept of premium you're not concerned with. And says that we have already addressed this issue many years earlier and quote, it is necessary that this issue is addressed for non-coal minerals also soon. Exactly what I am saying. That if there was
So this 25/5/22 public consultation note applies for all other minerals, right? Other than coal.
Exactly what I am asking. For iron ore, it applies and applies the same regime as coal.
It's a consultation.
Well, it's a recommendation. It's a clear written thing.
And the government is yet declared.
It's based on a committee's recommendation of Government of India.
Where do we find this?
Yes, this your Lordship will get
page 151 of our
151,
820,
which I believe is equal to PDF 185. PDF also.
820.
So that's the second strange, striking facet about this. And it is just that that explanation is there. Otherwise, everybody believes it's very unfair.
Start with that.
But assuming that there is a provision for royalty on royalty,
yes,
does that go into the constitutional validity? It's not a question of legislative competence.
It's not.
You're only really saying.
No, I'm saying manifestly arbitrary.
Manifestly arbitrary.
There is no basis, brothers, for saying, now let's come back to our ministry, our mineral, forget coal. Across the country, you get an average weighted price in Odisha for the last month. You have paid full royalty. Whereas there cannot be any basis for saying that the next month's royalty will include last month's royalty. And again, this, your lordship starts with January. Your lordship ends in December. This would be, it would be just some kind of a complete extraction without any reasonableness. Now come to the note of which I read less than half.
Do you want first down? Let's just read this note.
It's here only, no?
Okay.
This note is here, no?
No, in the.
Yes.
If you can.
Yeah, yes. This is 3-page note, not this bunch. It's only got documents.
They also explain everything.
See what the challenge is.
Yes.
What provision?
So see the explanation and then see
Yeah,
the
it's in this note.
Well, let's just see the explanation actually in the rule.
Where is it? Where do we get the rules?
Is it reproduced here? No.
Yeah, it's in the repetition.
No, not here, no, in this note.
No.
Well, your lordship will get in the
Because
repetition.
first let's understand
Let's take
what the statutory scheme is,
So first
what the
take-
rules say, and what therefore how it operates.
Take this book, Wallace, and see the 2016.
MMDR Act. Mr. Dwivedi, we are coming back to the MMDR Act after the 9-judge bench matter.
On that thing, explanation. My recommendations are all quoted at one place at 123.
But
very well. We'll see
that
from
we have
We'll see from
it's always better.
We'll see
to-
from here, no problem.
Which provision?
Now, let's the provision. Take that book. Give me the book now. Why do you take it? Open that.
Rule 38.
Rule 38 starts with sale value. Rule 38 of the MCR, which is Mineral Concession Rules,
1960.
2016.
Yes. It is at page, no, the Mineral Concession Rules 1960.
Yes.
Amalgamation of leases.
2016.
No.
No, it
Mineral
talks about
concession.
amalgam.
Oh, sorry, yeah, 2000.
Mineral Concession MCR 2016.
Yeah, we'll just try and look at it.
Universal one, it might be at
Universal books, it is page 486, but one is your option have a different book.
Which is the page in this book?
486.
In this?
Edition one, sir.
This is 2021.
So it may not be one of the editions will differ. But in the index, your lordship has got the MCR.
We have the entire.
Or your lordship, we have reproduced.
Atonement and Hydrocarbons Energy Mineral Concession Rules 2016.
That's the one. This is Pardiwala doesn't have it. This copy is not going to go. May I read it, please?
Yes.
Sale value is the gross amount. I'm reading 38 verse, which is under a chapter called Minerals Valuation. My case is only concerned with that. Sale value is the gross amount. Is the gross amount payable by the purchaser as indicated in the sale invoice, where the sale transaction is on an arm's length basis and the price is the sole consideration for the sale, excluding taxes, if any. There is no issue about non-arm's length sale and all that. And we are not concerned with taxes. Also, now in the 9 days held, royalty and taxes are different. We are not concerned with all that. Explanation. For the purpose of, Dr. got the explanation? For the purpose of computing sale value, no deduction from the gross amount will be made in respect of royalty. This is the problem.
This according to you is manifestly arbitrary and therefore invalid.
In other words, exactly, I beg to say yes. It is worse. It supposes that it could well be excluded impliedly and then puts a specific explanation saying it shall not be excluded. The assumption is that it would otherwise be excluded.
Sale value is Rule 38.
That's right, which I just read. My learned friends in the other matters have some challenges on the sale value also. I don't know those details, and they are also there. That's why they are additional. But this explanation, first explanation here, where is it?
38?
39?
Challenging all three.
Yes, we challenge the explanation as a whole.
Whereas we have challenged the explanation as a whole.
Even the committee's recommendations.
I must clarify, we are saying royalty, but actually the same concept applies to DMF and NMET.
Are paid in the previous.
Because the previous
no,
one.
But even if you succeed, at the most the expression royalty will be struck off from.
And the other two. I mean, we challenge the explanation as a whole. It talks only of 3 items.
Yeah.
So all 3, they're same, they are levied along with the same thing. It's called. So if it is struck off, it goes. That's all.
It's the compounding of all.
I can't ask for any. I don't need any rewriting.
It's a compound.
It's a malus.
Dr. Singhvi, your grievance is in respect of the computation of royalty on the basis of the average sale price. And then since average sale price includes royalty.
And these two other two also.
And two.
And
therefore,
it's the same concept.
There is a cascading word.
It's an ad infinitum, cumulative,
but then
cascading.
But your grievance then is not in respect of Rule 38, but Rule 39.
Well, no. First is the explanation of 38. That is the first stop.
Right.
Error is in the explanation to 38.
There is no explanation. Then I am prepared to take my chances, and I just read the recommendation of central government.
No, we want to first understand the statute.
It is on explanation.
Then we'll go to the recommendation.
38 is explanation.
Okay.
Clearly.
Now let's see how royalty is done.
Yes.
That you will get from 41.
But I'll see 39 also. May I read it?
Sure, you will.
Payment of royalty in case processing of run of mine is carried out within the leased area, then royalty shall be chargeable on the processed mineral removed from the area. In case of run of mine removed from the leased area to a processing plant which is located outside, then royalty shall be chargeable on the unprocessed run of mine, not on the processed product. Wherever the Act specifies that the royalty in respect of any mineral is to be paid on an ad valorem basis. Now, our case is, this is relevant. We are ad valorem. The royalty shall be calculated the specified percentage of the average sale price of such mineral grade concentrate for the month of removal consumption as published. Now, I'm not telling you. Explanation, I will have no grievance. Your Lordship will not be concerned. I will show it, of course, with 39, 40, 41, 42. Your Lordship will not be concerned with that. If the explanation goes, as far as I am concerned, it's okay. If your Lordship will now come to 42. My Lord notices, is my Lord on 42?
39 which says average sale price.
That's right. So that's why 38 adds that when you do average sale price, do not exclude royalty.
But 38 says sale value. There's a difference between it.
That's the same. The same value.
Explanation says for the purpose of computing sale value.
Correct.
Whereas royalty is payable on the average sale price. Sale price may not be the same as sale value, right?
No, but I believe it's the same for our purpose. It's the same. It's the same. Just see 42 months because the value is arrived at to go for the next month. There is no cavil and dispute on that price versus value figure. Come to 42. It will become clear from 42 months. You will also notice one thing immediately. Computation of average sale price. Keep it with you. The ex-mine price shall be used to compute the average sale price. My lord has got that? The ex-mine price of mineral grade or concentrate shall be what, Malas? Forget export. B. Where domestic sale has occurred, the sale value of the mineral. So it's intended. Malas, the sale value is the figure used to arrive at the sale price. It's as simple as that. Sale value of the mineral less the actual expenditure incurred towards transportation, loading, unloading, rent for the plot at the stocking yard, charges for sampling and analysis, and any other charges beyond mining lease area as notified by the IBM from time to time divided by the total quantity sold. Now pause here, Malas. It's very interesting that but for the explanation, none of these are saying specifically when you calculate the sale value or the sale price, you shall include royalty. It is the explanation by saying you shall not exclude royalty, you bring it in. 42 2B was the obvious place where you had to say it. And the cascading effect of month to month comes under 3. 42 bracket 3. Does my lord have it? Chief Justice got it. The average sale price of any mineral grade concentrate in respect of a month shall be the weighted average of the ex-mine prices of the non-captive mines. You are again ASP mines. Computed in accordance with the above provisions, the weight being the quantity dispatched from the mining lease area of the mineral grade concentrate relevant to each ex-mine price. That's the weighted average. I am a big player, he's a small player, he's a medium player. The weight will equalize everything else. Now your lordship will see the other provision also, which is the only other place again similarly royalties mentioned. Well, it's important to note as I leave this now. MCR, this is all. MCR does not say you shall levy, but by adding an expenditure shall not exclude. That's the point I'm making. Now come to 45. In the other, which is Mineral Conservation Development Rules of 2017. Where is it? No, in the book. We have 171. There's a difference of some 20 pages in your lordship's book, I think.
$189 perhaps.
Around 189. Maybe. Please forget that. No, but this is 45, not 45.
These are rules 2017, right?
48.
2007.
They are at page 150.
Yes.
Your lordship has got it at page 150?
Yes.
We require this rule 45, which is under the head chapter 6, notices and returns. And I'll be reading only 8 verses. Only 8 this explanation. Does my lord have something with the heading monthly and annual returns?
Yes.
All my Chief Justice Mishra has got it.
Yes.
May I read it? Now, Malas, according to me, 45 bracket 1 to 7 are irrelevant for my purposes. Just read the opening and then I'll go to the relevant one. The holder of a mining lease or any person or company engaged in trading or storage or use.
Just 1 second. I'm just.
No, my apologies. My apologies.
Yes, 40.
Your lordship's page starts at 169 of the book, Malas?
Yes.
Note 169 of the book. Monthly and annual returns. The holder of a mining lease or any person or company engaged in trading or storage or end use or export of minerals mined in the country shall cause himself to be registered online, etc. It's totally irrelevant for the case I am arguing, Malas. Now come to 45 bracket 8. We are only concerned similarly with the explanation. That's all. 1 line, 2 lines. Now, listen, 8, in case of mining of minerals by the holder of a mining lease. Now, I'm interested in the explanation just like the previous one, but I'll read the whole. Sale value is the gross amount payable by the purchaser as indicated in the sale invoice, where the sale transaction is on an arm's length basis and the price is the sole consideration for sale excluding identical or very, very similar to what your lordship read in 38. Because they put the expression in 38, they add it here also. For the purpose of computing sale value, no deduction from the gross amount shall be made in respect of royalty, DMF, and payments to NMET. Identical. And it's as simple as a endless.
Now, where is the this is only a definition of sale value.
Same thing, average sale price, average sale value, same thing here.
Yeah.
Identical, and the language is almost identical, verbatim. That's why I challenge only these two explanations.
Right.
And the basic point of the manifestly arbitrary is endless, repetitive, cumulative impact.
So why there are two sets of rules, 16 and 17? We looked into 38 of 16, and now we are looking into 45 of 17.
Yes. Well, this one is under notices, forms, annual returns, etc. This one which you should see now. MCR is following upon the grant. But on this issue, both are identical. It's not doubling both. It is both are identical. MCR is when the lease is given, you must follow the rules on the lease.
At the time,
the grant
of the lease.
This is how you file a form every month, every 2 months. This one.
That is 17.
That is 17. That is the heading is that. Kindly see 45. The heading is that. And a lot of other things come in, mining plan, etc.
Applicability to the 2017 rules state to apply to all minerals except petroleum and natural gas, coal, lignite, and sand for stowing.
Similar exclusion.
And minor minerals.
We are concerned with iron ore, which is a non-coal and separate. It's common to both. I mean, there is no problem. That's why Lordship has a separate thing for coal.
Now, under the 2017 rules,
yes,
what is the payment which you have to make?
The same payment, average sale price. It comes under
average sale price is used to determine what?
Royalty, same, identical. Well,
but is there a specific provision for the payment of royalty in the 2017 rules?
16 is the specific provision. 17 says you must file forms in identical language as 16. That's the summary of it.
But
it sinks, well, it sinks.
But you know, the royalty which is payable under on the sale price under the 2017 rules.
Is the same concept repeated because
we got the concept that the average sale price definition is the same in both rules. But where do we get the determination of royalty payable in respect to the 2017 rules?
No, 16 puts the levy on the basis of the grant.
Right.
17 says when you file forms, returns, when you calculate and give, you will give the same thing. That's why the heading of 45, see the heading is notices and returns.
Royalty from 16.
It's the same royalty of 16 telling you in 17 how you will put the form and how you will. There's no different concept.
All right.
Right. Now, let's just see 2 more documents and I'm largely done, Wallace. First, see the document at page 151 of which file?
Of the petition.
Of the writ petition, of my file. 151. Let's mark it. PDF is 185. 185.
Please read all the number.
You also use it there. Don't leave it.
Just explain it.
Low battery. I'm largely done then, except.
185, this is the note on consultation.
I beg your pardon? Yes, note for consultation. Now, now the actual notice is 2 pages earlier at PDF page 183, I believe. Please follow these pages of PDF. Notice for public consultation. Proposal for amendment. Well, this is everything is clear, but somebody doesn't have the urgency because millions of rupees are being paid on an illegal basis, so they don't bring in. Wait. Proposal for amendment for bringing reforms in the mineral sector. This is 25th of May, 2 years ago. MMDR was amended in 2021 with an objective to fully harness the potential of the mineral sector, increase employment, investment, increase revenue, increase pace of exploration, auction. Very laudable objectives, all impeded and obstructed by the actual levy. In order to augment the reforms made in the mineral sector, this ministry examined the proposal to make further amendments based on reports of committees and inputs received from various stakeholders. Accordingly, a brief is provided, etc. Then you skip this verse, come to 185. This is very interesting. This is not a consultation paper. It's a committee of Government of India which has gone into it in great detail threadbare. Calculation of ASP, removing cascading impact of royalty on royalty. This heading is extremely important. Removing cascading impact of royalty on royalty. Average sale price is the weighted average of sale value of minerals from each mine in a state. As per the existing rules, royalty payments to District Mineral Foundation and NMET are included in the sale value. Ad valorem royalty is calculated on the basis of ASP. It is also used in calculation of various auction parameters such as auction premium, upfront payment, reserve price for bidding, performance, security and net worth requirement to determine the eligibility for participation. Lordship will just pause here. The wider ramifications are very wide.
Are they referring to these 2 rules which we have just discussed?
Yes, directly.
Where do we find it?
Straight away, let me just complete. Straight away coming to that. Your Lordship will, but just note the last 4 lines. This doubling, trebling and quadrupling infinitely reflects on a lot of parameters. The auction premium you decide, the upfront payment, the reserve price, the performance security and the net worth. Just keep that in mind. Then para 2. Committee is held under the chairmanship of so-and-so. Members from Ministry of Mines, Niti Aayog, Ministry of Steel, Indian Bureau of Mines and ISI to examine the incidence of double calculation of royalty. The committee concluded that since the sale value already includes royalty and the other 2 months, the lessee pays royalty on royalty and royalty on DMF and royalty on NMET. Due to this, there is an additional charge on the miners under the current methodology. It's very simple and straightforward. The committee recommended to calculate ASP after deducting royalty, DMF and NMET. They all go together. It's doubling, quadrupling is the same principle. As ASP has become an important factor in the auction regime, it was recommended to include it in the Act for future certainty and stability in the fiscal regime in the mineral sector. The committee recommended to apply a new method of calculating ASP on both the cases, that is on mining leases, MLs to be auctioned granted after amendment to the formula, mark this, after amendment to the formula, and 2, the existing mining leases, including mining leases auctioned till the date of amendment. The MMDR Act of 2015 introduced auction of mineral concessions. All auctions take place by bidding on percentage. Royalty is also payable as a percentage of ASP in many minerals. However, ASP is not defined in the law, it is defined in the rules, which mandates non-exclusion of royalty. My lord, this is Pardiwala's query.
Okay, they are indirectly referring to.
Exactly. No, but they are dealing with that very subject. It doesn't, cascading doesn't come from anywhere. It comes only from 38 and 45.
In the absence of an amendment to the statute, does it become manifestly arbitrary?
Not in the absence, on its own. This is only a reinforcement of my submission.
Right.
Your lordship,
proposal for amendment.
That's right.
But does a provision of a statute become? Many statutes are sought to be amended. In the facts of this case, was the provision the unamended, the present provision, is it so manifestly arbitrary in the absence of the?
Therefore, my submission is, which I'll show. Just let me complete. I'll show that.
Yes.
That, it is manifestly arbitrary. I want to make a short digression on Article 14 orally. Your Lordship knows the cases well. And the fact that it is arbitrary is only reinforced by this piece of evidence. I am not saying that because the committee said so, it became in the course of time. But I am reinforcing my submission for Your Lordship's kind consideration that everybody thinks is arbitrary. There's no question of deleting it otherwise. That's all I'm saying. And it is a contemporaneous exposito of the understanding contemporaneously by the powers who operate this.
Yes.
Who administer. It's a contemporaneous exposition. Bills. Now kindly turn to Bills. The next 152. Charging royalty and premium on the sale value, which includes royalty, is not an appropriate way to collect revenue and leads to cascading effect. That's cascading effect is the Article 14 issue of both royalty and premium. It creates complications in changing royalty rates. Tomorrow, Your Lordship wants to increase royalty by 1% for some reason. Does it mean the intention is to have that cascading effect each month? Ministry of Coal had addressed this issue with a notification in 2012 itself for an identical system. The mineral may be different. It is deleted. It is gone. Now, just because one ministry sweeps over it, it doesn't mean that it becomes less unreasonable and I can't come to court. After all, this is part of the... May I read? Oh, I'm sorry.
As we understand your argument, average sale price, average sale value includes royalty, right? Royalty will not be excluded by virtue of the explanation.
In month 1.
Now, the determination of royalty is a percentage of the average sale price.
Lordship pleases.
Right. Now, according to you, since the average sale value includes royalty, then your royalty which you are computing as a certain percentage is also factors in royalties. But where is the bar in law? Because, what I want to understand is this. Merely because your average sale value includes royalty and the royalty component has gone into the determination of the average sale value, is that enough to say that it is manifestly arbitrary because the imposition of royalty is on a base which includes royalty?
So let me answer. Answer number 1, as I should put it will not require me to...
This is really a computation of royalty. That is a determination or a definition of the price, the average sale value.
No,
so if the average sale value has various components, including say freight, royalty, so on and so forth, cost, then merely because you have fixed your royalty as a percentage of the average sale value, does it become arbitrary? Is there any legal bar?
Yes, straight away. Answer number 1. I'll be very pointed with this, kindly. With greatest respect, Police, to show that this is unreasonable and therefore violative or manifestly arbitrary test, I don't need a legal bar. That's the first answer.
I don't need
a legal bar. If it is prohibited in a statute or in a regulation, I don't need the manifestly arbitrary argument. That's point 1. Let me just cumulative. Your Lordship will see the holistic cumulative impact, not any one. Number 2, add up all the straws and consider whether this becomes manifestly arbitrary. Unreasonable today, let me digress for 3 minutes of Lordship will kindly allow me. Your Lordship's fellows have a very fascinating story of Article 14. Without opening any pages, consider 3 minutes for us. when the Constitution was born, till roughly the mid-70s, your Lordship had basically non-discrimination as the main facet of Article 14.
It was really classification.
Not classification.
A classification.
You can classify, but
After Royappa, we made it really
comes
the doctrine of fairness.
74 Royappa, where your Lordship sowed the seeds of arbitrariness.
And then Maneka took it.
Then your Lordship had these Maneka, Brahmana, etc., all the way till the 80s, 90s, where your Lordships got arbitrariness, but my Lords camouflaged it by saying procedural due process. Or rather, that's the third stage.
And now it's the fourth stage, where we say manifest arbitrariness to be substituted.
Mr. B.N. Rao turnover in his grave with Justice Frankfurter, and your Lordship says we have substantive due process. Because Justice Frankfurter told Mr. B.N. Rao, do anything else you like, but for God's sake, don't use this phrase. So we picked up this Article 21 phrase from the Japanese Constitution. That was Article 20. Because he had some allergy to due process. Anyway, the fiction of procedural due process was given a burial by a series of cases by your Lordships, which includes, I just cite 3 Lordships, 20 of them. Tyra Banu, Joseph Stein, adultery, triple talaq, and Swiss ribbons, and many more. Now, what is manifestly arbitrary? Let us add up all and see the cumulative impact. Because manifestly arbitrary is nothing except gross unreasonableness. A simple word for it is gross unreasonableness. And now your Lordship is in the realm of substantive due process. Now, what is gross and what can be more gross than this? Number one.
In case, for instance, you are paying sales tax.
Yes.
Right?
Yes.
Now, sales tax is payable on the, I suppose, I'm just giving you a hypo, on the average sale value. Right? Now, suppose the average sale value includes the quantum of sales tax for the prior period. Does that necessarily become arbitrary by virtue of the fact that the sales tax for the subsequent period? You see, cascading effects are implicit in taxation. That's why GST came in. GST was a big reform to bring about, to obviate the cascading effects of tax, namely tax on tax. Because the tax which you pay at every anterior stage of the chain is given to you as a credit.
Therefore, may I say, a general...
But before the GST regime, it didn't become necessarily arbitrary.
I'm not on mere cascading. I'm just saying...
It is an economic argument. Dr. Singhvi, what I'm putting to you may be still right, but we are just still unraveling the matters in our brains. Is it an economic argument by your client?
Legal,
or is
purely legal.
Or is it does it then transgress from an economic to a constitutional law?
Has to. Otherwise, there's no question about it. I cannot say that have the tax rate of 97%
See, the consultation paper is right, that this affects the economy.
Yes.
Because, you have a cascading burden.
No, forget that.
But cascading burden...
Let me answer the 2 points.
Bad economics, but law.
First point is, exactly, it can be, certainly it can be. So 2 answers, your Lordship has given the GST example. Just leave it aside for 30 seconds. First, let me give you all the straws, which if added, according to me, break the camel's back. They may not. Straw number 1, you have a royalty here, not a tax. And your Lordship has hardly a few months ago decided that.
Right.
Earlier, it was slight confusion.
You have said that royalty
Now there is no confusion in this very jurisdiction. Number 2, there is no statute which says, but there was a time in the 70s when we actually had the highest slab 96% tax. Perhaps your Lordships could not hear a challenge saying that 96% is too high. Because it's a statutory imposition. There is no statutory imposition here. There is not even a regulation or rule imposition. That's number 2. Number 3, there is an imposition by an explanation added to a rule. Number 4.
Repeat that, no statute which says.
So number 2, Malas, this imposition.
So your first point is.
On
the aspect of unreasonableness, where you said that there may not be a legal bar, but still a provision can be declared as manifestly arbitrary.
As a matter of fact, when we argue manifestly arbitrary, we assume there is no legal bar.
Correct.
Otherwise, it would be ultra vires. Suppose there's a legal bar, all I have to show is the ultra vires. So, the whole idea of attacking it or assailing it on the basis of constitutionality is to say that this is manifestly arbitrary, and that's number 1.
It's royalty, not a tax.
Number 2, the example of other taxes as in taxes, may not be appropriate because your lordship in 9 judges have held is not a tax.
Correct.
Directly on this field, this concept, this royalty.
Right.
Number 3, the imposition is not by statute. That's number 3. The imposition is not by statute. Number 4 is very interesting ones.
Just a minute. Yes.
So number 3 is not by statute. Number 4 is very interesting. According to me, and I may be partially wrong in this, the imposition is not even by rule. Your lordship will not find any rule which says Five. The imposition is by an explanation which is in the negative, saying on an assumption that you should be excluding royalty, it says thou shalt not exclude royalty.
Correct.
Which is implicit, but I'm making a legal argument on it. It's implicit that it would ordinarily be excluded. There's no question of my saying don't exclude unless it is included. So that's number 5. Number 6. The manifestly arbitrary. The manifestly arbitrary is an endless monthly cumulative exaction. In 1 year alone, your lordship has, in a sense, it is like the old money lending act, fellows. This is a 2.5% per month, we used to say, 2.5% or 2% per month. It's for 1 year alone, compounded 12 times. Because ASP is only done monthly. That's number 6.
Section 9 provides for the imposition of royalty at the rates which are specified in the second schedule. Second schedule refers to royalty as an ad valorem for INO as a percentage of the average sale price.
Then we have no problem.
Now you are looking at the rule making power, which is section 13. In pursuance of the rule making power, they have defined average sale price.
That till there also I may not have difficulty. He may.
There's no difficulty there.
He may have. I don't know.
No, there's no difficulty there because
there's an explanation on top.
Because once the Act says average sale price,
Correct.
your rules can specify what is average
With
sale
respect,
price.
yes, with respect.
And average sale, now you say that average sale price has been defined to include royalty.
Suppose tomorrow,
and my royalty is defined on the basis, is determined on the basis of the average sale price.
Suppose tomorrow your lordship adds another explanation here.
Now tell us where is it a monthly payment? So you are saying there's a cascading effect by the month.
It is common ground that all auctions which determine price and ASP determination is done monthly. It is common ground to everybody. I'll give you also the practice also. 38 says the word monthly. Just check. I'll just check. Your lordship may take it.
So which one?
38. I'll just check.
Rule 38.
Just give me a minute.
We got it here, got it flag. Let's see that.
All the determinations, all the cases we are doing are monthly cycles, monthly or 6-weekly cycle.
Yes, you're right. 38.3. Shall be calculated the specified percentage of the average sale price of such mineral grade concentrate for the month of removal of a consumption as public.
Because you have to sell also monthly. The returns have to be filed monthly. 42.3. And 42.3 says it also, brothers. If you don't dispose of the mineral, you won't earn. And you can't remove the mineral without a monthly return.
Right.
42.3 says it also. 42.3 says it. No, but let me add, since your lordship.
So the whole argument really is this, that because the royalty is computed on the average sale price, and average sale price is not to exclude royalty, therefore royalty, which is a percentage, is on the basis of a
doubling, trebling, quadrupling, cascading, and
it's determined on a sale price which includes royalty. So royalty therefore is chargeable as a percentage of royalty which is included in the sale price.
I'm grateful.
Is that unconstitutional? We'll have to hear the
Simple
other
as that. Let me finish my 2 more points and I'm done with this. My lord has asked you a question. I've given 6, I think. 7. There are 2 reports in detail. One I have read, the second I have not read, brothers. Which says, one, we are deleting it now, one, we should delete it. The should delete it also is read. The cold one I will just read. This is not me. I'm talking a legal argument. Contemporaneous exposition.
Where is that?
The one your lordship is read just now. Recommendation.
Yes. Note for consultation.
Everyone?
We read note for consultation.
Yes, that's it. No, that quotes the recommendation of the committee set up by the Ministry of Mines. I'm not interested in the note, brothers. I mean, they completely quote a Government of India committee in the Mines Ministry.
That is page.
That is page. We just saw it. 181. My lord just read it.
181.
But see the second one now. See.
Notification of 14 July 2010.
Which brings me to my next point of discrimination. But
just read out the relevant part.
Exactly. In exercise of powers, etc., well, nothing is relevant except I. Below. Actual price means the sale invoice value of coal, comma, net of statutory dues. This phrase is a felicitous phrase, statutory dues, including taxes, comma, levies, comma, royalty, comma, NMET and DMF. National Coal Index, etc. Forget that. Now, just pause here. Pause. We are concerned with the last 3 months.
So the
last 3.
India and the Ministry of Coal came out with this notification.
Which brings me to my 8th point, which links to this. Your lordships may have a discriminatory approach between coal and non-coal for some other purpose. For example, Malas, export of coal. This is very important. This is Article 14, different facet. One is Article 14, manifestly arbitrary. This is a different facet of Article 14. You are making a directly culpable classification between coal and non-coal.
So this is meant for non-coal.
This is coal.
This is coal.
I am non-coal.
We are non-coal, right?
Your lordships can make for other, for example, coal is so important, so we can't export it. Others can be exported. It depends on what you are doing. For purposes of ASP, there is no difference. Well, your lordship may have a difference in terms of essential commodity, export, or something about railways, etc., or coal linkage. You can have a discriminatory regime. But when there is no nexus of difference between ASP in one and ASP in the other, in one you include royalty, in the other you exclude royalty. That is hit by the classification doctrine also of Article 14. I hope I'm clear with this.
Yes.
Your distinction cannot be without reason.
But tell us something, if MADA comes to the conclusion, a 9-judge bench comes to conclusion that royalty is not tax, right? Now, if a royalty is not tax, but a payment for minerals extracted, where is the bar in law on imposing royalty on royalty or demanding royalty as a component of something which includes royalty? But tax on tax you can't impose.
No, well, same thing. On the contrary, mine becomes a fortiori. If I'm not a tax, it's an a fortiori argument for me. Give me a minute.
Royalty is a price for minerals extracted.
Right.
So Mr. Dwedi's argument in MADA, which we upheld. Now, if royalty is therefore not a tax, but really a consideration for minerals extracted or removed from the leased area.
What is the nexus of having a charge of the previous month again in the second month? And again in the third month? There is no nexus. It's nothing. In fact, that is why you are saying, please note, I am now making it clear that should not exclude. But there must be some reasonableness is what was. There must be some reason and nexus apart from extracting. I'm asking myself.
But you are not challenging you are not challenging the provisions of the statute by virtue of which royalty is imposed as a percentage of average sale price.
Others are not me.
Right, in the statute. Now, the point of the matter is, question is, how do you compute average sale price? So, in a given case, they may say it may include cost, insurance, freight.
Not. Suppose tomorrow, your lordship adds another explanation. No, I'll tell your lordship. Suppose the lordship adds another explanation tomorrow, or the government adds, that you will include electricity in your room, office, insurance, the lordship puts it, and each month I will cascade it. Then, Malas, what is the meaning of Article 14?
But
you can add another explanation.
That post-manufacturing expenses issue, Empress Mills or entire.
The difference here is that the statute doesn't
be a matter for the legislature to define.
That is not the statute, but kindly note. The statute.
You are not challenging the MMDR Act.
Because the MMDR Act doesn't say what I am arguing on challenging. The regulations don't say, the rules don't say. You add an explanation to tell how to calculate. Well, suppose tomorrow another explanation is added saying that when you charge ASP, please calculate. Well, I'm giving an absurd example, but please see this.
You are saying.
Please charge my child's school fees also into that.
Let's flip your argument. Your argument is that any definition of average sale price
cannot be so absurd.
Must necessarily exclude royalty. That's your argument.
No, I'm not even saying that. I'm saying even lesser. Any definition of ASP must pass the test of reasonableness.
Which has to include royalty, exclude royalty.
In this case, royalty. But suppose tomorrow, in the same sentence the lordship adds, shall not exclude royalty, comma, DMF, NMET, comma, school fees of the person operating the mine. Well, I'm giving your lordship, the power is
for anybody
anybody
who's selling the mineral.
Yes.
All right. Suppose you extract the mineral.
Yes.
You sell it to me.
Yes.
Now, when you are selling it, you're factoring in all the levies which have gone into your cost, right?
Yes.
Which would also include your royalty.
No, but the fact that I am factoring
So if I'm a purchaser, I'm actually paying for the royalty which you have paid the government.
But that will not make it constitutional. If that argument is taken to its logical conclusion, nobody will be able to challenge it. The last man will get it.
That it does not therefore lose that link of the link. Some link has to be there in taxation. Some tenuous link is also sustainable.
Tenuous. First of all, we have reached the stage of tenuous link. So let us be clear. If link at all is a tenuous link.
But no,
second is
tenuous. Yeah, it's not tenuous. But see, average sale price. You are the person who's a lessee.
Yeah.
You have extracted mineral. You have sold it to somebody else. Your sale price to somebody else will factor in the royalty which you have to, because for you it's a cost.
So let me give you Ashok 2 or 3 answers.
For the extractor, royalty is a cost.
Well, on manifestly unreasonable, it does not matter at all whether I pass on the cost. If that reasoning is taken, nobody will be able to challenge. Everybody will pass it on. The challenge is based on constitutionality, but not passing on.
The fiscal burden.
No, with respect.
Maybe bad economics, terribly bad economics.
No, I'm purely on law. I forget.
Still valid law.
Well,
just has to amend it.
Everything. No, this is not that. I am saying Parliament is added. Delete the addition. Your Lordship is not asking me to rewrite.
That notification amended the schedule.
Your Lordship is not I am not asking your Lordship to rewrite. I cannot. I am saying delete the addition. Now just see apropos my Lord Distinguishes query 42.3. 42.2b.
Page 181.
Yes.
The notification made an amendment to the
by adding this
schedule to the schedule.
I am only saying that is beneficial. Otherwise,
the fact that they have not made a similar amendment to INO make it arbitrary. That's the point.
No, I am not saying that. I am saying
bound to make the same.
I am putting it the other way around.
Same
I am saying that it is evidence that what I am arguing is reasonable.
There's such a great latitude in these sort of matters.
No, two things. Let me answer. Query number 1, my Lord, is put to me more than once. Where is the bar? I submit with greatest respect and humility. There is no such test as where is the bar. I have to show it's manifestly arbitrary and unreasonable. I'll fail. If there's a bar, it will be ultra vires.
Again to do this, just sort of, because now we have seen the whole thing. That's all. On the other side, just formulate in this for 3 or 4 points why it is a manifestly arbitrary.
Yeah, I'll just do it again.
You did it, but
I'll do it again. I'll
do it again. Brother Pardiwala,
I'll do it again.
Notes noting, and I was thinking of something else. Just quickly, rapid fire.
No.
Fastest finger first. So you can give us those 5 or 6 points.
My problem is I may have forgotten also. My problem is I may have forgotten also. Let me give. Number 1.
This is like Dr. Singhvi is typical. Number 1. Number 2. I found in some matters that Dr. Singhvi has raced far ahead of his points. You see, he is actually on point. Because we are taking down and we are taking on point 17 and he is still on point 13.
Pointillism is a good school of thought to be invented.
No, it adds a great deal of clarity.
I'll help you.
No, I know you should note it down. I'll also got some noting. I told my husband to note down. But well, the first, I may not be in the order I said, but I remember.
Right, just tell us 3 or 4.
Number 1, well, it's the bar in the statute is not a test.
I think we can ask the other side is that look, this gets compounded by the month.
That's the factual heart of it. Factual heart of the unreasonableness is that. Just 2 or 3 more points and I'm done with very quickly.
Yes.
It creates also a wrongful classification between coal and non-coal, which for this purpose bears no nexus to any valid object to be achieved.
Second is, so there's not a statutory prescription.
Yes.
Then one is another point I've said so earlier, Justice Pardiwala would have noted it down. Because there is no statutory prescription. This is very important. Because the Lordship example, below the Sales Tax Act, etc., will stand on a different footing. In fact, as I said, I repeat it, there is no rule-based levy also.
So your argument is imposition is not by statute, imposition is not even by rule.
Obliged.
Comes in by an exception.
Manifestly arbitrary is because it is endless monthly cumulative exaction.
That's the point.
Compounded 12 times. Then you invited page 185.
That's the only point.
Two committees.
Page 181, article 14, classification.
One or more, I'm done with. Just see again 42 bracket 2 bracket B of the 2017 rules.
16.
16? 16. Sorry, 16. MCR.
All of the expenses. MCR.
MCR 16.
Rule 42.
Bracket 2, bracket B.
Page 151.
No, they are using the book. They are using the book.
He doesn't exclude royalty.
It excludes everything except royalty.
That's right. It doesn't exclude.
Yeah, all these are reinforcing my point. It's reinforcing my point about unreasonableness. I'm not saying that your Lordship will exclude. Everybody thinks it right to exclude.
Right.
Even the way the impugned explanation is formulated, it assumes that
let's hear the other side.
One other thing, one judgment. Please note the citation. I'm not reading this, but one judgment I'll read few paras. Joseph Stein. Sorry, Joseph Shine is 2024 5 SCC page 1. Paras are 200, 200.1, 0.2 and 0.4 where Lordship has put the conclusions. Shaira Bano, the triple talaq case is 2017 9 SCC page 1 para 101. I am reading the last third one, most important one is Manish Kumar, which deals with all the cases at one place. Just read 2 paras with me there, Manus. It's 2021 yes 5 SCC page 1. Kindly give me that title.
Para
6 to 56 onwards a few paras. So 64. Just come to 56. Give it to me.
All right, we'll look at it. Dr. Singh will hear it. I mean, these are well settled tests.
This is why it says this very thing. That by what I was saying is that by adding something, you create a levy where none existed. It can be unreasonable without there being a bar in law.
You got it, yes. There don't have to be a bar in law. As you rightly said, Dr. Singhvi, if there is a bar in law, you don't have to turn to manifest rights.
Joseph Wallace in this
then you will statutorily ultra vires. You don't have to go to the wider argument.
Very well.
That point you are right.
Just note, para 56 to 64.
You made it.
That Anwar Ali Sarkar is developed by Justice Joseph up to this current time.
Yes, Mr. Madia.
I'm deeply obliged. Very deeply obliged.
What's the challenge before your lordships in this particular matter, Manoj, is to
According to the outside.
8.2 is quite different from the other.
Narrower point because we will not conclude your case. Let's finish arguments on this and then we'll start your case because you have so much more.
So any observations not by prejudice?
No, the 8.2 is quite different from the others.
Segment immediately, so we'll complete this case first. Right. What do you say?
Excuse me for a short while. Excuse me.
Yes, sir.
The challenge before your lordships is Manoj's explanation to Rule 83 of the 2016 rules. Sorry, 38.
38.
I'm so sorry. The provisions, Manoj, have been placed before your lordships, but let me just, Manoj, step by step set out as to in what manner 38 the explanation was framed. First of all, Manoj, Section 9 of the Act, your lordships will have, provides for calculation of royalty. And it says that royalty is to be calculated at the rate for the time being specified in the second schedule in respect of that mineral. My lords has that.
Yes.
9 subclause 1. Section 13, as my lords noticed, is the rule making power. Therefore, my lords, the schedule is relevant for the purposes of calculation of royalty. And entry 24 of schedule 2.
INOR.
That's right. It says INOR. And in respect of INOR, it says that it shall be calculated at 15% of the average sale price on ad valorem basis. So the term average sale price, that is where it comes from. By virtue, my lords, of Rule 39 of the 2016 rules, royalty is to be calculated at the specified percentage of the average sale price. Rule 39, my lords, may just note.
Yes, 16, no?
That's right. 2016 is all I'll be referring to, my lords, because the challenge is essentially to 16. My lords have noted Rule 39 of the 2016 rules. Now, the method, my lords, for computation of the average sale price is provided for under 42.
I see.
Rule 42. And 42 subclause 3. So, Rule 42 2B, my lords, deals with the computation of average sale price, wherein the term sale value is a component. 42 2B, my lords, may just note. And 42 subclause 3 provides that average sale price of any mineral. My lords, may I just read 42 subclause 3 minutes for a minute. The average sale price of any mineral grade concentrate in respect of a month shall be weighted average of X mine price of the non-captive mines computed in accordance with the above provisions, the weight being the quantity dispatched from the mining lease area of mineral grade concentrate relevant to each X mine price. For the purposes, my lords, of computation of sale value, Rule 38 and the explanation to Rule 38 is relevant. And it is the explanation to Rule 38 I'll read first and then the explanation. Sale value is the gross amount payable by the purchaser as indicated in the sale invoice, where the sale transaction is on arm's length basis and the price is the sole consideration for the sale, excluding taxes, if any. Explanation. For the purposes of computing sale value, no deduction from the gross amount will be made in respect of royalty, payments to the District Mineral Foundation and the payments to the National Mineral Exploration Trust. It is only this explanation which is today in challenge before my lords. My first submission, my lords, we had of course filed an application also to that effect, is a preliminary bar in the sense that, my lords, this writ petition under 32 ought not to have been entertained. It could very well have been challenged under 226. The reason why, my lords, they appear to have filed a 32 is because on the basis that there are certain other matters which were pending before your lordships, but those matters, my lords.
In fact, I remember for a long time you were.
That issue was.
Mr. Nattaraj was appearing to show us what was a commonality. But at some point, I think we just.
But I must point out that no, your lordships have said that that issue is kept open and can be taken up at the time of final hearing. The issue in those matters, my lords, I would respectfully submit is quite different. And in fact, my lords, this is a challenge to the 2016 rules. Those, in effect, are a challenge to the schedule Schedule 2, which is framed under Section 9.
Oh, I see.
So,
should be scheduled
notification amending the schedule.
to the rule. 64 of the Judicial and the notification.
In any event, it has nothing to do with the 2016 rules or the explanation. Therefore, there was absolutely no reason why they ought to have filed an Article 32 petition. It should have gone perhaps under 226. In any event, that being my preliminary objection, my second submission is that this is at the end of the day a matter pertaining to a policy decision taken by the government as to what is the royalty and at what rate the royalty should be collected. In fact, if my lords, a lot was said about
not so much a challenge to the policy decision on royalty,
yes,
but on the basis on which the average sale price should be computed, and whether royalty is so completely alien to the average sale price that any inclusion of royalty in the average sale price would be manifestly arbitrary.
So therefore,
that's really how we
that's
can
right.
put
So
their
my submission is, which is why I read out the statutory provisions. At the end of the day, this is all a manner only to calculate the rate at which royalty is to be charged under Section 9. It has no other bearing. And that, my lords, is a revenue decision which the or a commercial decision which the government takes from time to time.
But your commercial decision is in conflict with this page 181. Which
it wouldn't be. I'm grateful.
So you need to make us understand.
Yes.
Why do you draw a distinction between coal and uncoal?
I'll just answer that.
Because
yes,
you admit that this cannot be included in the sale price.
I'll just answer that straight away. Insofar as
that's the principal argument. That's all.
Yes, my submission
is 14
Yes, my submission is, my lords,
that would be your policy decision.
That's right. So I'll just answer that. If, my lords, it is to be accepted that we cannot take or levy royalty at different rates for different minerals, my lords, that would, in my respectful submission, lead to, at the end of the day, even the existing schedule levies royalty.
The question is not of how to determine.
Yes.
The question is, if you say you can't include it, why do you include it in non-coal?
So my answer to that is, my lords.
And also you said it gives a cascading effect and therefore this requires.
So my lords, my answer to that is, if my lords has that annexure, page 151.
For coal, if it gives a cascading effect, why for non-coal it doesn't? Make us understand.
My answer to that is this. Even a cascading effect, my lords, at the end of the day has a bearing on the rate of royalty. And that rate of royalty, my lords, is within the domain of the government in terms of Section 9. And this particular page, which is the consultation on proposals, well, it's all PDF page 183. If my lords has subpara 5.
So you said cascading effect has a bearing on the rate of.
I'm saying even that effect, my lords, you may call it cascading effect or otherwise, but it finally, my lords, is a manner for determination of the rate of royalty, which I am permitted to do under Section 9. Unless it is shown, my lords.
So it is so disproportionate. It has to be, it has to be expropriatory.
Today, not a single fact or figure is even shown to your lordships to show that it is disproportionate. Other than saying it is disproportionate, absolutely nothing is placed before my lords. And please have, my lords, of that very document, which is PDF 183 at 184, subclause 5. The issue needs to be addressed through amendment. After all, my lords, at the end of the day, this is a consultation paper which says that perhaps this issue needs to be addressed. Merely the certain observations in this consultation paper, my lords, I would respectfully submit, cannot render a provision simply on this basis. On the basis of these observations, the lordships would not come to the conclusion that a provision is otherwise arbitrary, and as I was saying, not a single, my lords, fact or figure is placed before my lords to even show as to what is the actual financial effect. At the end of the day, my lords, what are they saying? They are saying the financial effect is such that it becomes manifestly arbitrary. In fact, my lords, page 183, if my lord sees the entire, it is an opinion of a consultative body and absolutely nothing more than that. छोड़ कुछ है. Lastly, my lords,
has the government taken any decision in pursuance of that opinion?
I'll check up. I'll place it in a note, my lords, before my lords. Maybe by tomorrow morning we'll place it. I don't. We have been trying to get the counter to be filed. Somehow it has not been placed before, my lords. And my lords observed, the 9-judge bench of your lordships has come to the conclusion that royalty is different from tax, and therefore, my lords, tax on tax would be quite different. Royalty on royalty will have to. That is. So my submissions will place a note before my lords for my lord's consideration. My lords, unfortunately, counter has not been filed in this matter.
What?
That's my side. It's at the end of the day, it's a commercial or revenue decision which is taken by.
May I respond, my lords?
Yes.
On the issue of the maintainability, my learned friend referred to an earlier order that said it's been kept open, but actually on the 2nd of September 2024, my lords have issued notice in our petition. They've chosen not to file a response, but that is that. The second is, my lords, a submission was made that we are quite different from the earlier batch. But what my learned friend has not seen is that the earlier MCDR of 1988 had a Form F1, which did exactly what these two explanations are doing. Just the only difference being that Form F1 implicitly did that. It said these are the exclusions or these are the inclusions, and it did not mention royalty. But now with the explanations, what was implicit has been made explicit. So there is absolutely no difference between the old regime that my learned senior Mr. Mehta and Mr. Vedi are concerned with and the present one. Lastly,
instructions this evening on whether the government intends to take a decision on the consultative paper.
We can check up.
You can check at a fairly senior level because you had a consultative paper. You have done something for coal. You're not saying that there has to be absolute parity because these are different minerals. The productive resources are different. The market pricing is different. The conditions for extraction are different. We're not saying the Article 14 argument. But you have a consultative paper. What is the government proposing to do on that?
Check it up.
You can then just come back to us.
One more submission, my lords. My learned friend submitted that this would be covered by Section 9.3 in as much as the cascading effect would have a bearing on the rate of the royalty. But would my lords have Section 9.3 for a moment and the proviso there too? The proviso says the rate can be changed but cannot be changed for a period of 2 years. If my learned friend is right, then this rate is changing every month. If I may read 9.3, my lords. 3 years, sorry. But my learned friend just submitted that in fact it has a bearing on the rate. So he's trying to defend it on 9.3. Surely it will then be in breach of the proviso.
All right, we'll close it for arguments now. And tomorrow morning, when the other matter opens up, you can just tell us. All the other matters are common right now.
Yes, I think
yes, they are.
You can tell us tomorrow what is the government's position on the consultative paper. I mean, have they taken any steps? Is there any process in the government which is going on?
Very well, Manoj, I'll do that. May I just reiterate this request in the other matters, Manoj? It's a wider scope. Permit us to file a...
Wider scope is the easiest to deal. We don't need any counter, nothing. You have to just apply the law.
But there's no response filed in that, Manoj. We'll file it within 3-4 days. There is a delay on our part, undoubtedly.
We'll open it. If we find that we'll be handicapped without a counter, we'll...
Very well.
Yes.
My lords, allow us to file a note by tomorrow?
Usually there are counters. But how many times do we refer to a counter in a virus matter?
That's right.
And we're not going to hold that the government therefore has admitted the invalidity of the act. We're not going to draw that inference. It's not like a civil suit.
Very.
Continue the list tomorrow.
Yes, yes.
Lord,
8.2.
Would my lords allow us to file a note in this matter by tomorrow? Just to summarize Dr. Singhvi's arguments.
Dr. Singhvi has already given the note. No?
We could...
Okay, you can give by tomorrow morning. You can give the note.
I have one request, my lord.
Yeah, Mr. Madiyal, you can also give the note.
We'll do that.
This one-page note is enough.
We'll do that.
Because you've argued it, you've made detailed submission.
We'll do that.
Notes. But just a one-page bullet point, you know, anything that you've missed out right now.
One request, my lord. Right. Item 8, my lord, I'm in the lead matter. We missed the online appearance portal, my lord, morning.
Yeah, no problem.
Please.
No problem.
Great.
Yes. Have you people sorted it out? Who is? वो ऐसा कर लो उसको कल रख दो. We'll keep it tomorrow. We'll list it tomorrow. Because we have not dictated anything.